the learned.
What do you want?
Well, this should be listed for fresh admission, my lord.
Give it. We'll see.
I beg to-
All the reviews will be listed.
I beg to pardon, my lord.
Pursuant to the order passed by the Honorable Supreme Court, we have filed this review application. So,
You took the liberty there.
yes, took liberty.
They did not interfere, then.
Yes, yes, yes.
This is the
Yes.
assignment of old building two
There
matter, my lord.
there is no case then. Okay.
My lord, this is the
In the
assignment.
event the review is dismissed, the petitioner is again given liberty to.
Oh, that is there because of that judgment. Otherwise, that is forfeited.
My lord.
That is why the earlier regime was different. Even if you review without taking liberty, you can't challenge the
Yes, yes, yes.
So therefore, that liberty has to be
My
taken. Yes.
This is the assignment of old building two matter, my lord. Electricity matter, my lord, without considering my so cause.
No, the old building two means what?
My lord, Mr. Justice, Honorable Justice A.K. Mahapatra,
Yes.
my lord. My lord, this is the electricity matter, my lord. Last 4 days, they have disconnected my electricity connection, my lord. Urgent, my lord, tomorrow, my lord. Nah, this is not. Tomorrow, obliged.
Electricity is disconnected.
4 दिन काट दीजिए
This is commercial premises or residential premises?
commercial, my lord.
Commercial.
Commercial. Small businessman, my lord.
It's all right. Commercial.
With-
Keep it on 24th. Huh? 24th. Okay.
This is the
24th.
Last-
When it is disconnected?
last 4 days, my lord.
4 days. Wait for one more 2 days. 24th, I'm listing it.
My lord,
24th.
may I pray that review petition will be listed next week or
Yes, yes. He'll do it. Don't worry. He'll do it.
Your Lordship, this is an FOA matter arising out of Odisha Protection of Interest of Depositors Act, my lords. It was,
FOA is assigned to me today only.
my lords, it was,
Wait for some time.
my lords, what has happened, it was posted today to be specifically argued at 2 p.m. But because of this change of assignment, could not be.
We'll
I
see.
believe next week,
Give-
my lords,
give-
any
we'll
day
see.
next.
We'll see how can.
Much obliged.
Because the change of assignment, we have
Silence.
to adjust things, no?
My lords,
Yes.
much obliged, Your Lordship.
Petition of the lady lordship petition of the lady lordship challenging the order of cognizance. There is no interim order on the last occasion call for the.
What do you want?
Taken.
Cognizance order.
This Lord, my Lordship,
yes.
seeking pardon to mention one matter, Lordship.
Yes.
My Lord, this matter was heard on the last month, 2012, and my Lord has given a specific date for today, listing of the matter. But the matter has not been.
Give the
listed.
number, we'll see, because of the change of assignment and all, this might not have been listed. Just I'll check it up. Please give it. Give the number.
My Lordship.
Yes.
Yes, Lordship. My associate is there. I'm
Yes.
obliged, Lordship.
Yes. Yes.
This
Yes,
week, in this week, Lordship, please,
Yeah, we'll
in this week.
We'll see. Yes. Any
Like-
mentioning?
May I please, Your Lordship?
Order, please. Yes.
My lord.
Yes,
item
madam.
My lord, item number 55, my lord.
1 minute. Please, wise, I'll call. Yes.
Lordship.
Pardon, Your
Yes.
Lordship. One criminal appeal of the year 2010, Your Lordship. Now the appellant,
Wait. The appeals, wait.
my lord,
Just
the
see.
appellant is now 70 years old, Your Lordship.
All the appellants, when they come to this court, they are more than 70. Don't worry. Few of them has died also.
My lord, previously I was mentioned, my lord.
Well,
my lord.
just give the memo, include it in the weekly.
It's compensation matter, FO matter. Two FO. One is of
Okay, all
2000.
the matter will come serially. Don't worry.
My lord,
Unless the
2000.
pressing urgency, I'm not going to.
My lord, permanent disablement cases, my
It's
lord.
all right. Every
2000.
case has some story behind it.
Huh?
Give the memos, we'll see.
Yes. And to make a mention, my lord, challenging the order of cognizance, this petitioner has filed this CRLMC. Admittedly, the petitioner was a juvenile at the time of occurrence. This Honorable Court directed the State Council.
Who has admitted? You have admitted yourself.
My lord, but the state has also
Agreed.
filed the document. Admittedly, the petitioner was a juvenile. As per instruction of your lordship direction. In spite of that, urgent,
Give the memo.
that matter could not be listed. And another matter, extension of time.
Extension of time for what?
Extension
Surrendering.
of time not to surrender within the specified period for that reason.
Oh, this I'll give you immediate relief.
Yeah.
ये जल्दी लगा दिया स्टेट देखिए लगा ठीक yes yes
Item 1, nursing, item 1, nursing, may be taken up next week any day. My senior will not.
Adjournment request.
Interim order.
Since 2022. And the similar issue that are raised for the repetition and after filing of counter, it was withdrawn. This special court matter, the
Special order.
proceeding is.
Interim order.
So that's the whole difficulty. Once interim order is there, this.
Maintainable. It's a hyper notification.
So short date, short date, Mr. On behalf of Mr. Moon, an adjournment is sought for. Mr. Maharana opposes the adjournment, leaves the matter. So 27 may not be possible because see 80, 90 matters, especially urgent matter. And now the assignment is increased. Let us see. देखिए कर दियो जोड़े की hearing ही पर.
My lord, item 4. Item 4.
That is the only interim order. Only for interim order you are asking for adjournment. Otherwise, yes.
My lord, item 4 being 1 week after.
4. 1 minute. 4 on request. April.
1 week after.
April last week.
Oh, bless me.
One.
One. And 2 you are saying it's 2.
8 to 22,
Yes.
item 23 to 30, 31 to 35, 36 to 41, 42 to 47.
Item 44 lordship taken on 1 week after lordship.
44.
Lordship.
Okay. On request, adjournment. Yes.
48 and 49. 50 to 57.
Item 50, your lordship. Here I have taken consent of my senior Mr. Mishra also. Next week ended, your lordship.
Adjourn on request.
May I please your lordship? My lord, item 55, your lordship.
16 matter.
Ma'am.
2016 interim order is going on. This is against what? Cognizance. 1 minute. It's against cognizance.
My lord. Sorry, dispute between uncle and nephew, your lordship.
And that's right, but 2016 you have taken.
Next week ended, your lordship.
No, next week I am not here only for this matter. And I'll wait, let it come. Wherever there is interim order, if you want adjournment, then
Your
you will
lordship,
pay some
Friday.
cost to the bar.
Your lordship, Friday.
I have decided now, today from onwards, you have to pay some cost to the bar.
Your lordship, Friday, your lordship.
No, I can't, take up the matter like this. Because the board is so heavy, you are taking advantage of that, then you pay some cost to the bar.
On the Friday, your lordship. Due to some
There is no question of accommodating within this 2-3 weeks. All these matters will go in the March only.
your lordship,
Can't accommodate. Give.
I have also
the
taken
matter is,
consent. I have
The matter is pending since 2016, and the petitioner has been enjoying the interim order dated 19/9/2016. The repeated adjournments have been sought by the petitioner. Today also there is a request for adjournment. In the interest of justice, adjourned to so and so, subject to petitioner paying a cost of rupees 1,000 to the High Court Bar Association.
lordship. Friday, your lordship.
Bar, what is the
Friday, Friday, your lordship.
No, I can't accommodate because of the assignment. Just see the assignment. I can't accommodate. I can't accommodate like this. You pay 1,000 rupees and to the bar, an interim order to continue. This is the matter. Bar Association. You enrich your bar. Okay. Yes.
May I please your lordship?
Your lordship,
My lord, item 50.
500, your lordship.
For you, 1,000 is nothing. Pay to your bar only you are paying. Okay, 500. 500. Yes.
My lord, item 55, my lord. Kindly taken up the next week, your lordship.
Item 20.
55, your lordship.
Is there any interim order?
Uh,
Is there any interim order? No interim order? Yes, list of requests. Okay. Yes.
Oblige your lordship.
Item 58 to 66,
58 to 66. Yes.
7 and 8.
Permitted to make a mention.
Yes.
Sorry for bothering your lordship for the second time on the same cause of action. Last week I had mentioned regarding interim maintenance, there is a stay here because she had already, it was finding that she had deserted the husband. So there was a stay when I filed the 482 application. In spite of that, she filed another CRP for execution of that maintenance order. In that maintenance order, date was also fixed. Although there was a stay, date was fixed. Now order has been passed to struck out my evidence. I cannot give evidence in the final.
You give the.
So,
Okay. Yes. Item 2.
item 2.
May I please, Your Lordship? Your Lordship,
Yes,
may
madam.
kindly adjourn this matter for the next week.
The request adjourned. It will go to April. Okay.
Item 3.
So you adjourn now to there is no interim order put it in April. Yes.
Lordship, item 3 mediation successful ହେଇଯାଇଛି DD ଆଉ gold exchange ରେ କିଛି issue ନାହିଁ ଅଛି report ବି ଆସିଯାଇଛି
Mediation report?
mediation report
Then in terms of mediation report,
Lordship ନାଇଁ sir ଟିକେ ଅଛି କଥା କଣ କି flat ଟା registration ହେଇ ପାରୁନି କାଇଁ ଭୁବନେଶ୍ୱର ହଉନି କି ଜଟନେରେ ହେଇ ପାରୁନି ଖାଲି ଟିକେ modify କରିଦେଲି your lordship ଆମେ registration କରିଦେବୁ 5 ତାରିଖ with consent of my senior
mediation ମାନେ
by non-entrance is because they have now prohibited or banned with regards to transfer of flats. So if permission will be granted by this court because of this mediation report, as per the basic upon the basic mediation report.
But I can't. There I don't.
There, Bernard, I was. He has suggested me. He has suggested me.
Papa भी ଥିଲେ उभयंको presence रे mediation
If
report
there is some impediment in registration.
No, they want to do other alternative thing. The power of attorney will be given in favor of the
power of attorney नहले right title interest declaration
Given undertaking that as and when registration is open, we will register it. As simple as that.
On fifth ballot or other requirements which is there.
Then I'll keep it on fifth.
Ballot.
Okay, keep it. The mediation, the matter was referred to mediation center.
Fifth or sixth ballot.
District mediation center. No.
No,
High Court mediation.
High Court mediation center. Mediation was successful.
The parties have participated in the mediation process and the mediation came out
good gesture.
Successful. Council for the parties request to lease the matter on 6th of February so as to execute the terms of settlement, lease the matter on. Okay.
Except parties be present कर दो सर गोटा उभय पक्ष भी अस्थिर
Why to travel? They have participated in the mediation. Why to bring them?
I was saying no.
Why to bring them?
sir उभय party ready
Mediation center is the extension of this court only. They have appeared.
Rightly, both the parties have appeared and they have.
Yes, sir. Data sitting rate concluded.
It is not very pleasant to call to the people. Yes. Yes.
5.
In this case, it's avoided but if we non-filing of requisite notice and the issue, and if you file the same so in the court of the
Why have you not filed, madam? And the notice was issued in November 2024. Give 500, okay, to the bar. Okay, notice was issued to the opposite party number 2, wide order dated 26/11/2024. However, the petitioner has not filed the requisite as yet and seeks time to file requisite within 2 days. Let the petitioner file the requisites for serving opposite party number 2, subject to petitioner paying rupees 500 to the bar High Court bar. And the requisite may be accepted. Yes, release the matter.
Item 6.
Yes.
Please, Your Honor. This is the case of cognizance order having passed by the court, dated 5th of January 2021. Under section 399 and there was 402 of the IPC has been imposed onto the petitioners.
Yes.
So the fact of the case, Lord, as per the prosecution.
Yes. Yes.
While the petitioner along with other 2 accused persons was prepared to commit the dacoity in the locality of the alleged crime scene.
Yes.
That time, police was received unreliable information from any other person and just spotted out to that alleged crime scene. And they were found 4 persons, 4 persons, and police was seized only 1 bike And allegedly, they are just mentioned on the FIR that some dangerous weapon have been seen.
Yes,
in
yes.
the record.
Why should it be quashed?
Look, there are the only 4 persons have been named on the FIR.
Hmm.
Which 402 of the IPC section said where there is a more than 5%. Then only it is able to get committing the dacoity of. Please may have the 401 of the IPC.
Just see in the charge sheet how many?
That's, you know,
319.
25. That's now. Anecdote of 25.
Yes. How many accused are implicated here?
Only 4, my lord.
IPC यार IPC भी नहीं है क्या? Yes. Yes.
You can have the 402 of the IPC.
Yes, sir. Proceed.
Or whoever at any time after passing of this act shall be 1 or 5 or many persons assembled for the purpose of dacoity shall be punished with rigorous imprisonment for a term which may extend 7 years and shall also be liable to fine. But there are only 4 persons. And
Yes.
please may have that page number 33 that the prosecution has mentioned why not they just
Yes.
they're not able to identify the accused number 5 who is the unknown person.
There is unknown person.
Yeah.
5
on the
people
FIR,
are
they
there.
mention on the unknown person.
Yes.
But on the charge sheet, while they are submitted charge sheet, please may have the page.
Yes. What do you say?
Another person is escape.
Escape. You are not able to identify. After investigation, you are not able to identify.
No.
Then how will you prove? How will you prove 402?
Are they really satisfied because 5 persons are there, evidence is there also.
Two,
5 persons are there.
5% in the absence of identifying the 5th one. How will you establish the case?
But really satisfied.
Ingredient is satisfied. For cognizance,
Yes.
for cognizance it is done.
Yes,
For
yes,
cognizance
yes.
it is done. You argue at the stage of charge.
Yes.
Right. Petitioner is agreed by the order
Yes,
dated
36.
order dated 5/1/2021, passed by learned JMFC Udaygiri in GR case number declared so whereby the court below has taken cognizance of offences punishable under section 399/402 IPC against the petitioners against the petitioners. Then counsel for the petitioner submits that the investigation is complete and charge sheet has been filed in the present case on 31/12/2020 against 4 accused persons. He submits that for the purpose of attracting such the offence under the 402 IPC, minimum at least 5 accused persons should have been participating in the crime. However, in the present case, only 4 charges have been filed against the 4 accused persons. The counsel for the state submits that the 5th person he escaped from the spot has not been identified by the police. However, the ingredient of 402 IPC is satisfied. Therefore, the trial court has rightly taken cognizance of the offence under section 399/402 CRPC. I'm in agreement with the contention raised by the State Council. Hence, at this stage, I'm not going to take this petition. However, liberty is granted to the petitioner to resolve the point before the court below at the appropriate stage. With this liberty, the petitioner is disposed. Yes, next.
Obliged.
Yes.
May I please, Your Lordship?
Hmm.
My Lordship, the petitioners are challenging the order dated 21/9/2023, filed under Annex 3, my Lord, the cognizance order dated
21/9/23. Yes.
21/9/23,
Yes.
filed under Annex 3, my Lordship, the page at page number 30 to 31, my Lordship, for the order taking cognizance of the Law and Trial Court with the basing of the protest petition of the present complainant, my Lordship. The last occasion, my Lordship directed to file the complaint petition, which is available on record at flag P, my Lordship.
Yes.
My Lordship. The protest petition along with a certain order dated, my Lordship.
Yes.
That, my Lordship, here in this case, that, my Lordship, after filing, after the police officials or investigation officer filing the final from that, the case was entirely the false one, and due to the civil dispute, the present petition, the present complainant filed the same, and filed the.
How many of you are there? 10.
My
10
Lordship,
people.
my entire family, my Lordship. Petitioner one along with the entire family. That son, then the children, the brother-in-law, entire family were implicated. My Lord, I may be allowed to, my Lord, kindly have a glance. The page number 22, 29, my Lordship, the 25, my Lordship, the brief fact of the charge sheet, final form, my Lordship. 25.
I know, charge sheet, forget. Come to the protest petition and 202 statement. Whether
Well,
the case is made out or not, just tell me.
That, my Lordship,
Soon after the brother.
only basing on the statement of the victim, my Lordship. No, there is no other independent witness, my Lordship.
What is the statement affidavit? Statement of the 202 statement.
That only the statement of victim, only the statement of the complainant, my Lordship, the cognizance was taken, my Lordship. That order dated, my Lordship, 11/9/2023 reflected that the advocate for the complainant is present, file memo stating that complainant does not want to adduce further evidence in this case. Hence, the 202 inquiry is closed, put upon acquisition for passing necessary orders.
Come to page 43. (202) statement, 200 statement.
My Lordship.
Your name, or the name of all of you have taken.
My Lordship, is the statement of the complainant, my Lordship.
Then
The complainant. No
the
other.
complainant statement has to be discarded.
My Lordship, that's why I'm referring the page number 32, my Lordship, the independent witness statement. My Lordship.
Where is that?
In the petition.
That is in 161.
That is the independent witness, my Lordship.
That is in the 161 statement. I'm only talking about the 200 statement.
It is the
Protest petition. See, for cognizance, what I have to see. Protest petition
my Lordship.
and the preliminary evidence.
Inquiry report, my Lordship.
Yes.
Yes,
Preliminary pre-summoning evidence. If any case is made out, cognizance is taken as simple as that.
Case, my Lordship,
161 statement, they might have said something. That is the reason closure report was filed.
My Lordship.
And thereafter the protest petition.
My Lordship.
And then you have to see the contents of the protest petition
No,
and the statement made.
the witness is available to establish the case against
It's a
the
different story,
petitioner,
but
my Lordship.
prima facie case is
That's
there.
why I'm my Lordship, only one thing, my Lordship. Kindly have a glance on cognizance report, my Lordship.
Yes.
The page number 30 and 31. The last one, 31, my Lordship, kindly have a glance.
Okay.
My Lordship, it is found that is prima facie material available on the record. Case will proceed against the accused person, namely Gangaraj Sabar, my Lordship. Gangaraj Sabar also a person which belongs to ST community. And cognizance taken against the Gangaraj Sabar in SC Act, my Lordship.
Is Gangaraj Sabar is a petitioner?
No, here in state not a petitioner, Gangaraj Sabar.
Then why are you arguing for him? Let him come.
I'm just informing this.
No,
my Lordship.
informing you. So let him come. You are Ponda, all Pondas.
But I am my Lordship, I am an advocate practicing at Gurupur. I am present at this spot to solve the matter, but to grave and to take revenge, the present complainant.
You want to settle the dispute?
Entire my family.
If you want to settle the dispute, I can help you.
My Lordship,
Otherwise, you don't have it.
what kind of settlement? my Lordship?
Don't waste time. You simply don't waste time. Will you settle the dispute? Then I'll issue notice.
Then I'll kindly issue.
Otherwise, you argue that at the stage of framing of charges. These are the two options available to you. Argue at the stage of framing of charges because cognizance is correctly taken.
I'm not setting the my lordship.
No further argument. You two options.
Then my lord kindly issue notice.
I'll issue notice, try and settle it.
My
Because you are a lawyer, why you are wasting
my
time?
entire
with this?
family, my brother-in-law.
Issue notice to opposite party number 2, returnable notice so and Mr. So-and-so accept notice for the stay. And then counsel for the petitioner submits that he will make all endeavor to see that the matter is settled out of court. Out of court. Please the matter on so.
My lordship, my IA is pending.
No, stay. Yeah, next.
Okay.
Maybe yes. This application is filed to quash the entire proceeding on the ground of compromise. Compromise? Compromise has already been held. Your lordship kindly fix a date so that the petitioner and the informant will appear before your lordship. Okay. Mr. Naik, counsel for the petition submits that the parties have already arrived at a settlement. On the basis of the settlement terms, he seeks intelligence at the court for watching up for the criminal prosecution initiated against the petitioner by the opposite party number 2. Opposite party number 2. Issue notice to opposite party number 2. Returnable when? Anytime, let's say kindly fix next week. Being tomorrow? Being tomorrow? Tomorrow, this informant will come from Borgod Mallet. She's a lady. Online. Online, let's see, be personally present. Okay. First week. 29. Okay? Being there. Okay. File the process. Yes. Yes.
May I please, your lordship, challenging the order dated 8/9/2020, passed by the learned session from special judge, the petitioner for this hearing. On the basis of the FR lodged by the OP number 2, initially FR was registered against the present petitioner along with another person in an offence under 3,294, 506, 34 of the Indian Penal Code, relative section 25, 3R S of the SCST Act.
Yes,
The
yes.
prosecution story has like this manner.
Now, why should it be quashed, you tell me?
But there was a dispute between the husband and wife. Accordingly, a village meeting was convened. In the said village meeting, it is alleged that the wife did not agree to join with the informant, OP number 2. And there was a quarrel, and the petitioners are the villagers. Though the informant alleges that he was present in the meeting, village meeting, but the co-villager, including the wife of the OP number 2, has disputed that all the petitioners, along with a dead person who was earlier dead 2 years ago, was not present. And accordingly, the police has submitted the final report that this is a mistake of fact. Without issuing notice to the informant OP number 2, the learned session judge has taken cognizance. In the meantime, the wife and the informant have settled their dispute. They are residing together. I am the villagers. I have no role at all, my lord.
Who is the wife?
Wife is running page 18. Your lordship may kindly see running page 18. Urmila Sethi.
Who are you then?
I am
who is Kedar Sahu? Who is Pramod Kumar Sahu?
Co-villager.
Huh?
Co-villager.
Co-villager, but are they related with either the wife or the husband?
No.
Yes, what do you say?
Running page 18, your lordship may last 6 lines from the bottom. Sehi meeting re Pramod Sahu, Kedar Sahu, Pulin Sahu nathile. Tonkadar Sahu mori jaisanti. Pulin Sahu Gohira Chakare Kirana dokan de aji ku 10-15 ବର୍ଷ ହେବ.
Where are you reading? Which statement?
Urmila Sethi,
Okay.
the wife of the informant.
Okay. Yes.
In fact, the husband gives some medicine for mental disorder medicine to the wife. For there is a dispute and the wife is residing with her parents' house. But the husband informant stated that he was giving the blood pressure medicine.
Okay, let us see the charge sheet. What are the allegations against you?
My lord, 51 last page.
Last page?
51.
Okay.
51 ର last paragraph ଲେଖାଛି as except the complainant and his interested witness, no independent witness proved the allegation by the complainant. I return this case as final mistake report of transfer.
What kind of charge sheet is this? Rightly taken cognizance.
Your lordship may see the
statements are there. Then the police investigating agency IO says that the interested witnesses, therefore I will not take into consideration. Who is he?
The entire villagers have stated that.
Maybe entire village, but who is he to say that they are interested witness? Therefore, I will not take into consideration their statement. Who is he?
Informant or Bappa. Out Tana Sangre
No,
Dija.
it is, but there are 161 statement.
Madam.
It is only court can say that.
Madam.
Either interested witness, so therefore I will not rely upon that statement. Who is the IO to say interested witness, so therefore I will not take into consideration their statement. I will file a closure report.
In fact, there was a settlement and the wife is residing with the informant.
This
Petitioners are the villagers, they have no interest.
I think the IO has done wrong. That is the reason the trial court has rightly taken comment.
In the meantime,
IO should not have said that interested witness I will not take into consideration.
The state.
There are witnesses. Maybe you interested, maybe may not be. Because in the village, the relative and all. Maybe. And he has no option. If there is evidence, he can't discard some evidence saying that they are interested or whatever.
But in fact, they are the villagers.
IO doesn't have that jurisdiction to say that. I think you argue on this stage of charge. Okay.
In fact, both the husband and wife are residing together. I have mentioned.
See, I could have interfered, but
issue notice.
I could have interfered, but there are APST Act and everything is there. That's
in fact, they have issued 41 notice to the petitioners during the course of investigation. And
are you apprehending arrest?
Detention by the court below, as because in the summons only notice to the present petitioners for their appearance, and no notice was issued to the informant, so that in persons of the summons, if the petitioner
it's not required. If the charge sheet is filed, and from the charge sheet material, if the court thinks that some case is made out, court will take
lordship.
at that stage, the informant may not be issued notice. If the closure report is accepted, in that stage only informant is required to be noticed, because he has the option of filing a probate petition.
Remember one thing, my lord, before the vacation, your lordship has directed to surrender by deputy.
I don't remember.
The Lord Session Judge send the petitioners to the judicial custody. For that reason, I was mentioned once occasion. May I submit one thing, my lord?
It's completely. Case is there. That's
the issue notice to the informant, my lord, so that can be settled. Your lordship may kindly see para 6 of my petition, page 6.
Yes. Para
6 VI, running page 6 of my petition.
Yes.
The alleged dispute was arose due to the matrimonial dispute between the informant and the wife of the informant, and in the meantime, they have settled their dispute and leading happy.
Which paragraph you said?
Para 6 of my petition.
Yes. It is also recently submitted and the dispute was arose so and so. Right. Petitioner by taking me to the ground number VI of his petition, page 6, which reads agenda, submits that the parties have already settled the dispute. Continuation of this proceeding will be an abuse of process of law, and no fruitful purpose would be served if the prosecution continues. In prescribed terms, he submits that the parties are willing to settle the dispute. On that ground alone, notice is issued to let notice go to opposite party number 2. Opposite party number 2, retainer will be to the phone. Yes.
My lord, I have filed one miss.
I have issued notice, no stay.
My lord,
because officer case is made out, I can't stay. I am just trying to help you out because to settle. I'll give a short date. Wait, I'll give a short date. Otherwise, I'll have to relegate you to the trial court for arguing at the stage of investigation. There is no case made out. How can I give a stay?
Yes.
I'm trying to help it out because if they come forward, I may try to settle it. Wait. And I'll give a short date so that you can file the process fee immediately. Yes.
May I please, your lordship? Here, my lord, the petition filed under section 227 CRPs for discharge has been whimsically rejected by the Lord and Court below, without taking into the facts and the 161 statement available with the charge sheet, my lord. Lordship, what happened? The present petitioner and the informant, they both are assistant teacher and posted in different district government high schools. 5 years back, they develop some affairs. Stayed together near about 5 years in living relationship. The present petitioner's father, parents, they accepted the informant as daughter-in-law. Thereafter, the lady, the informant, she alleges that I have some doubt the present petitioner have some relationship with other girls. Then the affair was lost, cognizance has been taken, and then I filed a petition under section 227. That has been rejected. Lordship, come to kindly the 164 statement attached with charges.
Yes.
Page 53.
53.
53, my lord.
Okay.
This is the 164 statement of the victim. May I read?
Yes.
ଏଠାରେ ଉପସ୍ଥିତ ହେଲି ଏଇ ବୟାନ ଦେଉଛି
When have already been examined. Arrest of the witness could not be turned down to the court and no coercive action is taken by the court how they will came and depose the deposition. I pray simply to target the trial errors.
No, the FIR is of 2021.
Yes, my lord. That's true, your lordship. But trial begin.
When the charge sheet was filed?
Trial begin, your lordship. 24/7/2023 trial has been begin. Charge sheet of the case filed, your lordship. 17/4/2021.
21.
Yes, my lord.
Yes. How many witnesses are there?
Only 10, your lordship. Out of which 7 examined.
Only 3 remain.
Only 3 remain. They are not coming to the court, your lordship.
Can I just see?
The order sheet will be glance.
If they don't come, they don't come. Where is that? Which
Yes, I am the victim of the case, your lordship.
which proceeding you are talking about?
I filed the order sheet, your lordship, that starts from your lordship.
PW1 examine accused persons already been examined. Today she is cross examined. Which proceeding? According to you, that the court is not taking steps.
No, so far the rest of the witness, their summons has been issued, they are not coming, your lordship. Summons has been issued, but that they are not coming. PW6
319 petition is filed.
That has already been considered, your lordship, and so far the recall petition that is allowed the witnesses those are required to be recalled. There is a PW6 and 7. This is the present petitioner and his mother, her mother. They have also been appeared before the court. Everything has been completed so far.
Hey, how are you saying that the trial court is not taking steps?
No, steps in the sense they are issuing summons, your lordship. I am not saying they are issuing summons, your lordship, but the rest of the witnesses are not turning. My case is that if they are not turning for deposition, then there is option before the court to take coercive has to be issued valuable warrant, your lordship.
Okay. Petitioner by invoking the inner jurisdiction of this court under 482 CRPC seeking quashing up the seeking a direction to the CJM cum ASJ Bhadrak for early disposal of ST case number 30/70 of 2023. 2023. The case is emanating from an FIR registered on 19/2/2021. The charge sheet in the present case has been filed on 17/4/2021 for alleged commission of offences punishable under section 452, 294, 323, 427, 342, 354, 307, 379, 34, and 341 of IPC. In the charge sheet, there are 10 witnesses named. Out of them, the 7 witnesses have already been examined. Insofar as the remaining 3 witnesses are concerned, summons have been repeatedly issued to the said witnesses. However, they have not turned out, as a result of which the trial is prolonged. At this stage, the petitioner has filed the present petition seeking the direction as mentioned above. As mentioned, he submits that the trial court should trial court should issue a stringent process against the witnesses.
Remaining witnesses.
Remaining witnesses. so that the evidence of the prosecution could be concluded. Yes, it is possible. The contention of Mr. General and counsel for the petitioners reverse merit. Accordingly, the present petition is allowed. The trial court is directed to do and to see that the three remaining witnesses of the prosecution shall be examined as expeditiously possible. For that, the trial court is at liberty to issue a stringent process against the three witnesses. And it is also
And only dismissal of trial.
and needless to say that the petitioners being the accused have constitutional statutory right of free, fair and speedy trial. Hence, the trial court that also agree that the trial is considered as possible. Yes.
Obliged.
Yes.
Your Lordship, I am on VC, my lord.
Yes.
Petitioner,
Yes, sir.
petitioner earlier was not in bail. As per the statement of the co-accused, petitioner implicated in this case, my lord. This is the
Yes.
year of 2016 case, my lord. As per
Yes.
the prosecution report, the informant performing patrolling duties, he got reliable information, assembly some criminal and making preparation committed docket, my lord.
What do you want?
I want to bail, my lord.
Huh?
Against the petitioner,
Petitioner is agreed by the order dated.
NBW issued.
NBW issued on
11/5/2016, Your Lordship.
11/5/2016. NBW has been issued against the petitioner. As the petitioners have 1 minute. The petitioner has been absconding.
Yes, Your Lordship.
Absconding. The charge sheet in the present case has been filed way on 10/5/2016, showing the petitioner as an abscond. At the belated stage, the petitioner is seeking quashing of the NBW order issued by the court below. Then counsel of the petitioner on instruction submits that the petitioner would be appearing surrendering before the court on or before 30th of January 2025 and reserved to be remedy available to him under law. Regarding head to the aforementioned undertaking, the NBW issued by the court below. Wide order dated
11/5/2016, Your Lordship.
11/5/2016 shall execution of the NBW issued against the petitioner by the order also shall be kept in evidence till 31st of January soon. It is made clear that no further extension for surrendering appearing before the court below shall be granted to the petitioner. With this observation, the petitioner is disposed of. Yes, next.
15.
May I please, Your Lordship? My lord, this is a case of 2015, and I have been charged with the 376 as well as POCSO 6. And now I have given a petition under 311.
3 SC/ST also.
I also said that I have been given a petition under 311 for recalling the informant as well as the victim. And they have also given an affidavit that they want to come to the court. The court or lower court below has not allowed because they wanted a speedy trial. But it is already 10 years past. So if we given a chance to recall them, then the things will.
No, they have settled the dispute now. Have they settled the dispute? Have they settled the dispute?
But they have given an affidavit. My lord, page 32 of the petition, para 2.
Yes.
Actually, it is almost compromised. They have given para 2.
Victim is already married.
Married and she is staying at my neighbor. She doesn't want to pursue the things.
She is your neighbor.
She is my immediate neighbor.
No,
that's why she has told that it is a previous enmity I have given.
Now stated there is the above petition restored to the directions from there is the material on record in the case of the year 2015 after examination of all the witnesses when the record is set for evidence. PW1 is the victim.
Victim.
Victim is the
Victim and
child.
PW2 informant.
Is the minor child. Huh?
Minor.
PW2 is the father.
Father.
Found that 376 POCSO. How will you get over this page 33? The reasoning of the trial court.
My lord, they want to that SPD it should be completed. That's why. But 10 years.
2015 they were examined.
My lord.
And after 9 years, you are moving an application under 300.
But after 9 years, the victim has changed her mind and she wants
so
to.
Therefore, I have to write a reasoning to set aside an order of this kind. To support some judgment, something you have to give. A judgment which is well-reasoned judgment, I have to set aside that. Unless I have some supporting judgment or something, how can I set aside?
My lord, give me.
I'll simply say that I don't like each
No,
case.
no, no. My lord, I have got the apex.
I have to write a reasoning. See the reasoning.
Okay.
How to get over that reasoning?
My
You have to give me some material so that I can get over that reasoning.
My lord, give me 7 days time. I'll give.
Yes, I'll give you a date. Please come out with something.
Yes, I have got Supreme
So the
Court.
problem with you is twofold. First is the PW1 and PW2, no problem. PW2, one can do it. PW1 is the child witness.
My lord.
This victim girl. The POCSO is involved. There is a bar under 33(5). Okay, it's not an absolute bar. My judgment is that. This is one issue. Second issue is 12/8/2015 they were cross-examined.
My lord.
And now at the stage of defense evidence, you moved an application 9 years after. Therefore, the trial court says that the special statute case, time-bound disposal is there, I can't allow it. There is a legal bar.
My lord, give me 7 days time, I'll give the apex court.
Simply urgent. You just give some, I understand, because it can't be quashed now, you are going to be convicted.
My lord.
Once you are going to be convicted, you are staying adjacent to their house. It will complicate the life of both of you.
Correct.
But what to do now? Find out some way. Simply adjourn it after first week. Yes.
Item 16, please, my lords.
Here.
My lords, here, under section 482 of the CRPC, my lords, I have filed to quash the criminal proceedings, my lords, on the pretext that it is entirely a false case, my lords, which has been manufactured by the victim girl for personal vindictive reason. The lordship may straight away come to page number 17.
17?
17.
Okay. Yes.
My lords may see paragraph number 6, with the 164 statement has been recorded by this honorable court in an anticipatory bail application, wherein it has been held that on a perusal of the case diary, specifically the statement of the victim recorded under section 164 CRPC, it appears that she has admitted about relationship with the petitioner and that she had a quarrel with the petitioner on 17/4/2024. Now, your lordship may note, thereafter, she has lodged this FIR making false allegation against the petitioner. The victim has further stated that she does not want to proceed further in the present case as the foundation of the present case is baseless.
And if you notice, petitioner, Mr. Mishra and counsel for the petitioner, taking me to the order dated 6/11/2024 passed by the coordinate bench in AVP number 9070 of 2024, whereby the anticipatory bail application of the petitioner has been allowed.
Yes.
Pointed out that the statement of the prosecutors was recorded during the investigation under section 164 CRPC. In the said statement, she has admitted that she was in relationship with the petitioner due to the misunderstanding and quarrel taken place on 17/4/2024. She had lost the FIR. In that regard, the para 6 of the order of the coordinate bench had been highlighted by Mr. Mishra, which reads as under para 66, para 6, para 6. Issue notice to opposite party number 2, returnable so. Mr. Vishwal accept notice. In the meantime, proceeding before so is stayed. Yes.
Great.
File the process be otherwise I'll vacate process.
Malus.
Okay. Because stay is very dangerous now.
Sir, there has been compromise also.
That's the reason I am.
She has already married to another person.
You immediately file the
Yes,
requisite so that first week requisite of quasi. She has already said that she has already settled.
The difficulty is the girl may not appear, my lord, because she has married to some other person. Now, if it is disclosed, she will be in trouble. That is the whole difficulty.
Then how to do it?
Well, because of her statement, 164 statement is there, clear statement.
No, that on
And
that basis,
she has also filed an
on
affidavit
that
in the court
basis it
below.
can't be quashed. If it is settlement, she has to come and give an affidavit. Otherwise, the trial court will see.
Trial court
We
now, this
can't
man will be unnecessarily.
I can't take into consideration 164 statement and I quash it.
Let us see if she is appearing all right, my lord.
You do
If
it.
she is appearing all
Otherwise,
right.
you can direct the
No, my lord, let notice go.
IO to
Let
serve
notice
the-
go. If she appears, then it's all right, my lord.
If you have settled, you go and take the notice, that's the and serve her and bring her.
Yes.
17, may I please, Your Lordship? Order of cognizance is under challenge on the ground of, my lord, compromise. The case is arising out of a civil dispute between the parties and the petitioners and the informants.
What is civil about 307?
My lord, civil, they are co-villagers and
Attempt to murder is civil.
no, my lord, the injury report found to be, if your lordship will see the injury report, I have, my lord, it is been indicated in the brief of the facts. Your lordship will
Show me
see.
the injury report.
My lord, the injured, your lordship may see the injured statement.
Yes.
So I have also made them party. And in the meantime, compromise.
show me.
Your lordship may come to page number 24.
20?
24, your lordship.
Oh, okay.
The statement of the injured, your lordship.
Yes.
Yes, your lordship. May I place your lordship?
Yes.
My lord. More namo Sudarsana.
Come to the relevant part.
My lord, the first three line, ମୋ ପରିବାର ସହ ଆମ ପଡୋଶୀ ଘର ପଦ୍ମଚରଣ ଜେନା ଦି ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଓଗରେ ଘର ବାଡିକୁ ନେଇ କଳହ ଥିଲା 7/6/2026 ତାରିଖ ଦିନ ସମୟରେ ମୋ ଭାଇ ବାନାମ୍ବର ଜେନା ଆମ୍ଭମାନ ଗୁହାଳ ଘର ଆଜବେଷ୍ଟସ୍ ପକାଇବା ଯୋଜନା କରି କାମ କରୁଥିଲୁ। ଏହି ସମୟରେ ଆମ ପଡୋଶୀ ପଦ୍ମଚରଣ ଜେନା ଅନ୍ୟମାନେ ମିଶି ଗୁହାଳି ତିଆରିକୁ ବାରଣ କରି ଆମ ବାସଗୃହରେ ଆସିକି ମୁଦାଲା କାଳୁଚରଣ ମେଘନାଥ ଶ୍ୟାମ ଜେନା ନୀଲୁ ଜେନା ପ୍ରଭୃତି ହାତରେ ଖଣ୍ଡା ଶାବଳ ପ୍ରଭୃତି ଧରି ଭାଙ୍ଗି ଚରଣ ଉଦ୍ୟମ କଲେ ପଦ୍ମଚରଣ ଜେନା ଦି ରେଲିଭେଣ୍ଟ ପୋର୍ସନ ଦ୍ୟାଟ ଲାଷ୍ଟ ପାରାଗ୍ରାଫ କାଠରେ ମୋ ମୁଣ୍ଡକୁ
ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଶକ୍ତ ପ୍ରହାର ମାରିଲା।
ମୁଁ ସେଇଠି ପଡି ଚେତା ଶୂନ୍ୟ ହୋଇଗଲି। ତାପରେ just bear for a moment, 9/6/2000 ମିଲର୍ଡ 9/6/2016 ତାରିଖ ଦିନ 10ଟା ବେଳକୁ ମୋର ଚେତା ଆସିବା ପରେ ମୁଁ ଜାଣିଲି ମୁଁ କିମ୍ ହସ୍ପିଟାଲ ଭୁବନେଶ୍ୱରରେ ଚିକିତ୍ସିତ ହେଉଛି। ନା ୟୋର ଲର୍ଡସିପ୍ ମେ ଟର୍ନ ଟୁ ଦି ବ୍ରିଫ ଦି ପେଜ ନମ୍ବର 21
ତା ତଳ ଲାଇନରେ ଲେଖା ହେଇଛି ମୁଁ
21 brief of the facts.
Next page.
Page number 21.
20. Yes.
The injured stated that he was treated at Kim's Hospital, my lord. Now the police has obtained the injury report from the Som Hospital. Your lordship may see that the swelling 21, your lordship got it.
I don't know, he might have been shifted. I don't know. Where from I'll get all this?
That is the brief.
Then I'll have to appreciate evidence and
that is for that reason, my lord, I state that, my lord, all the matter has been settled.
You have given the blow in the head.
No, so far there are 5 persons who are involved, my lord. 5 persons have been implicated in this case.
Case is
so far the present
head injury. He lost the senses. He was in the hospital, admitted. Next day he regained the sense.
My lord,
this is the nature of
the injury report as reflected in the brief note. It is a swelling only on the back side of the injured back. Your lordship, I'll place, my lord.
Where is that?
My lord, page number
Where is
20.
the injury report?
My lord,
given?
21 injury report, I have
That is
annexed the entire charge sheet.
Where is the injury?
My lord, injury report is not there in the charge sheet
You
itself.
get that injury report first. Issue notice.
Yeah.
Get the injury report. first.
CDS.
CDS.
Notice, your lordship may issue notice to both the
But
parties.
this is not a case for quashing.
My lord, it's a matter of 2016. Till date, there is no progress after the taking of cognizance 2017. Till date, my lord, there is no progress in the trial.
I'll issue notice.
In the, my
Issue
lord,
notice and get the CD.
Yes, sir.
Let me check it.
returnable within a short period of time so that both the parties
First week or second week.
will physically appear, my lord, the injured and the informant.
But it may be difficult. Well, I'll just check.
Up to your lordship appreciation.
Okay. Okay. Try and get the injury report. Let us see.
That definitely I'll obtain by the next.
Yes.
And the government may also obtain the.
That I have seen. Yes. Next.
Yeah.
Oh, yeah. Yes.
In this case, the petitioner is the husband, and I challenge the execution case, the notice issued by the JMFC PPL. The notice itself is a ambiguity as the already.
You are challenging what?
The notice issued by the JMFC PPL about the execution of maintenance.
Yes.
As prior to the execution case, the annexure 5 of the case, the Honorable Family Judge Puri have disposed of case allowing the divorce and a permanent alimony of 12 lakh rupees.
Let's see page 42. The relevant.
Page
42.
14.
42. 42.
Yes.
That the divorce
Yes, I
decree
got.
passed by
I issue
the-
notice. I'll issue notice. Issue notice to.
Interim I8. I8.
In the meantime, petitioner. No, execution of the maintenance. Maintenance you have to pay.
The court without hearing from me issued NBW.
After.
They have that order, permanent alimony 12 lakh.
In addition,
Where is that NBW order? Show me.
I now also.
NBW.
Page 60.
So NBW. Issue notice to opposite party number 2.
Date of appearance रे NBW कर रहे हैं.
Also for the petitioner submit that the execution court has issued NBW by order dated the JMFC PPL by its order dated 4/1/2025 has issued NBW against the petitioner in the execution case number 77 of 2024. The regarding head to the fact that the petitioner and of the opposite party, the marriage between the petitioner and opposite party has already been dissolved by, where is the order? Dissolution of marriage?
Order.
By
NBW.
dissolution of marriage. Judgment. Where is the dissolution of marriage?
Resolution 42.
42.
Page 40.
Family Judge Puri in CP case number 11 of 2021, while its judgment dated 24/8/2024. The execution of the NBW dated issued provide order dated 4/1/2025 by JMFC PPL is state with request of hearing subject to the petitioner if appearing for the execution court on or before 10th of February 2025 and this up to the remedy available on the law. Yes, issue notice. Yes. They were 25 February. Yes.
90.
May I please the lordship, my lord?
Yes.
The petitioner has earlier gone, my lord, challenging the Lord and Trial Court order, insisting upon me to adduce the evidence unnamed witness, my lord. Thereafter, my lord has pleased to pass the order and pass that order. Again, I am called, my lord, by the annex of 1, my lords.
Yes.
Yes. My grievances, my though 354 and 499 offenses made out. But learned court below didn't take into consideration only two cognizance 448, 294, 506, 34 along with the SCST Act, my lord. From the initial statement under 20202, my lord, the case is clearly made out, my lord. Pursuant to my lord's direction, the cognizance was taken, my lord.
Now, what is your grievance left now? What is your grievance now?
Well, should have taken cognizance under of offense 354 and 499, my lord. That is clearly made out, my lord. I have the annex the statements, my lord.
448, 294, 506, 34, everything is taken. And SCST, everything is taken.
354 is there, my lord, along with the defamation.
Evidence will come if at appropriate stage.
The evidence is there.
Evidence. This is only cognizance says.
Yes, my lord.
Lead the evidence. What is the problem? How many times you will keep on coming? I gave one indulgence to you.
Yes.
And you laid 202 statement now you have recorded. And thereafter cognizance is taken.
In that 202 statement, that
and
is.
the evidence is there and you will.
There are also other provision 260 framing of charge.
There are other provisions. Why have you come? Right on, withdraw. Right on. Petitioner is agreed by the order dated 14/11/2024, whereby cognizance of offences punishable under section 448, 294, 506, 34 IPC read with section 3(1)(R)(S) and 3(2)(VA) of SC and ST bracket POA Act 73 has been taken against the opposite parties. Petitioner is the informant in the present case. I am not inclined to entertain this petition at this stage, being premature, as other remedies are available to him under law. Hence, the petition is disposed of with liberty to the petitioner to resort to the remedy at the appropriate stage before the trial court. Yes, next.
I am a lawyer, my lord, and being humiliated by the opposite parties, my lord.
So, all right. Lawyer, you should practice unnecessary. Don't waste time in the court litigating for yourself.
Obliged.
Yes.
20.
Yes, sir.
The petitioner and the opposite parties 2, 3, and 4 minutes. To basically 2 minutes.
Yes.
They entered into a commercial contract.
Yes.
And accordingly, Milad, the ship carrying the gold arrived at Dhamra port. But Dhamra port doesn't have that kind of tie-up with that particular company, ship company, for which the coal could not be unloaded here. So it was diverted to Gangavaram port, and the coal that was carrying for me, I had paid the amount carrying for me. It was unloaded there in that Gangavaram port and sold away to somebody. The entire payment was made.
Sold to?
To somebody else.
Yes.
And then there was a talk, and the talk could not yield any result. I filed a complaint petition, before the London Magistrate Chandbali. And under section 156(3), it was referred for to the police for the purpose of investigation. After the investigation, charge sheet was filed under section 418 and 34 of the IPC. In the meanwhile, when the criminal case was instituted because of non-payment of that amount, there was a settlement arrived at between the parties. From the settlement was, I have annexed that annexer 2 annexer 3 sorry, 2 at page 24.
Yes.
Allotment just is such an settlement,
Whose mail is this? Who has given the mail? Who has given the mail to whom?
Opposite party. That is a settlement I also accept.
So on the ground of settlement, you want?
On the ground of settlement,
commercial transaction, you have paid
half of the money was paid to me.
You pay whatever you.
No,
if the complainant is agreeing, then I have no issue.
No, I am the complainant.
Then what do you want now?
I wanted withdrawal. And that was rejected on the ground that since the accused has not appeared,
You got your money back.
I got
50% you got.
I got half of my money back, and the other half was Milad agreed.
Yes, what
to
do you
be-
say?
My lord, here, my lord, the process is not yet been begun. For that reason,
What process, Milad?
The problem is we are unnecessary stuck to procedural thing.
At least,
There is a pardon in the system. He initiated a proceeding. It is a pure commercial transaction.
Yes.
Something has happened between them.
Yes, sir.
A case was filed by him only. Now they have settled the dispute. 50% he got. He doesn't want to continue. Let him close it. Why unnecessary?
Exactly, madam.
Getting into so many technicalities, this, that.
There are provision 256 here.
Oh, okay.
What provision?
256. You know, two kind of.
You take out notice. I'll list it on 27, 28.
Milad, in fact, I think they will be appearing to a lawyer. They have instructed.
Let them appear, but
But appearance will be only from my office.
maybe. And you will be enriched otherwise.
Well, let it come tomorrow, Milad. Oh, that will come from Singapore.
Let it be 29, sir.
29.
Notice.
29.
29.
29. huh?
Yes.
Issue notice to opposite party. Opposite party 2 and 3. And 2 and 5. 2 to 5. 2 to 5. Just file the process fee because ex party is something shouldn't happen tomorrow. I know, but see the technical.
That is the procedure.
Yes.
No, nothing.
So and so except
Supreme
notice
Court
of-
has brought the Supreme Court.
Nothing will happen.
Yes, exactly, Milad. Nice.
Yes.
21.
Yeah. See,
Yes.
the page 41.
41. Yes.
The
Yes, sir.
Petitioners. The civil suit is pending at the instance of petitioner, where the order of status quo has been granted by the learned civil judge. The informant in the FIR under Annexure 1, which is sought to be quashed, he has violated that order of status. For that, as many as 8 FIRs have been lodged from the side of the present petitioners. They have not been allowed to.
You have registered 8 FIRs
8 FIRs against the informant.
for violation of the injunction.
No, not only violation. The petitioners are not allowed even for ingress and outrage from their house. In every situation, they have been assaulted.
What are you doing, by the way?
Now,
What are you doing, all of you?
just workers, farmers and workers.
And you keep on filing FIRs.
That is the whole difficulty. The informant is a rich person. He is humiliating the petitioners in some way or other. And violating also the order of.
You have filed 8 cases against him. He has filed 1 case against you.
Yes.
You want quashing of that.
Not only quashing, what I pray before your lordship, let the notice, the petitioners are on bail now. Let the notice be issued.
Let us concentrate. Why should it be quashed? You tell me.
Let the.
No. Why should it be quashed? You tell me.
Because intentionally this FIR has been lodged to counter blast of those cases.
So let us see what are the allegations.
Yes.
Counter blast or not, that will be decided in the appropriate stage.
And what has been
Inferred
what is the allegations?
Investigation is on.
Also ସମୟରେ ଆମ ଆସିବା ସମୟରେ ଆମ ଗ୍ରାମର କାହ୍ନା ମହାନ୍ତି ବିଚିତ୍ର ପିତା ବିପ୍ଳବ ଏହି ସମୟରେ ଆସାମୀ କାହ୍ନା ପୂର୍ବ ଶତ୍ରୁତାକୁ କେନ୍ଦ୍ର କରି ହଠାତ୍ ଆମ ଘର ମଧ୍ୟକୁ ପ୍ରବେଶ କରି ମୋର ସ୍ୱାମୀକୁ ସେ ଧରିଥିବା ଏକ ହଂସୁଆ କଟୁରେ ତାଙ୍କ ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ହାଣିବା ସମୟରେ ମୋ ସ୍ୱାମୀ ତାଙ୍କ ହାଣିବା ସମୟରେ ମୋ ସ୍ୱାମୀ ତାଙ୍କ ବାମ ହାତ ଟେକି ଦେବାକୁ the petitioners are the injured, no injury at all.
All these things I can't infer because investigation is still going on.
Yes.
How can I interfere at this stage?
Only the notice we issued.
No.
Only
no. We are increasing work of the court. In FIR is registered. It is a 307 case, 326. Investigation has started at the beginning and you coming to the court for questioning. Make out of different stories. And all the stories, I have to infer the stories and to question.
The petitioners are the injured. No injury. For that, the magistrate.
Where
the magistrate have
you
released them on bail.
show me from your
The
petition.
magistrate have released them on bail.
Show me from your petition any annexure that you are injured.
Yes, that the injury report, though I have not, with me, those are certified copy of with me. I have not annexed.
To keep it at the appropriate stage comes, let counsel for the petitioner seeks to withdraw the petition to revive his prayer. If cause of action still subsists at any stage, the petitioner is seeking quashing of FIR number so and so registered against them for alleged offence of punishment under section so and so. The investigation in the present case is still going on. At this stage, petitioner seeks indulgence of this court for quashing of the FIR. I'm not inclined to entertain this petition at this stage being premature. However, liberty is granted to the petitioner to approve to revive the prayer at the appropriate stage if the cause of action survives. Yes.
22 dispose of the case. Resolution. Petition is challenging order dated 23/11/2024 annexure to page 15.
Yes.
For no steps was taken in the execution case and DW and MW was issued for non-payment of previous matter. Settlement, I am ready with.
You are the husband.
Yeah, I am the husband, my lord.
What is the area?
Area, my lord, 9,75,000.
You pay?
My lord,
Settlement means how much you want to pay.
so that's why I am ready with a draft of.
I'll stay the proceeding, go and appear and tell the court. Okay. In the execution, I'll stay the NBW, go and appear, I'll give you time.
Yes,
and tell that court that I am ready to pay and finish.
Ready to pay that, because some other disputes are there. I'm ready to.
You confine to this case. So all the dispute I can't settle in this petition. No. I will stay the execution of NBW and give you time.
Yes, ma'am.
Before 10th of February, you go and appear and pay whatever and settle the dispute.
I am ready with around like 80,000 draft. So the balance of for the
go and tell that court.
Your lordship, I am ready fast.
Go and tell that court. Right. Petitioner is agreed by the
mention the amount.
Order dated 23/11/2024 passed by the family judge Bhubaneswar in criminal execution 39 of 2024. Whereby NBW has been issued against him. The petitioner, the opposite party number 2 has initiated the execution proceeding for executing the order of maintenance passed in her favor due to default in making good the maintenance amount. The impugn order issuing NBW impugn order has been passed issuing NBW against the petitioner. And counsel for the petitioner submits that he is ready and willing to settle the dispute with the opposite party number 2, and out of the LA's due amount of 9 lakhs is offering
1,80,000 draft.
He has prepared a draft of 1,80,000 and offering the same to deposit before this court. Taking into consideration the aforementioned, the NBW issued by the so by the order dated so is state execution of NBW state till 10th of February subject to the petitioner depositing the 1,80,000 rupees draft for the trial court and appearing in trial court. The petitioner is at liberty to enter into settlement dialogue with the opposing party by appearing before the court on or before 10th of February. Yes, sir. With this observation, the petition is disposed. You deposit there?
Yes, ma'am.
10 before 10. I have recorded. Yes. Disposal. Yes.
23. May I please lordship, my lord, this is a case under section 294, 333, 341 and 503 IPC, my lord. If I am taking the plea of RV because by that time I am in the school and my attendance is next to 2. I put my citizen. I gone from school by 4:30. Like
That plea of LMI has to be proved in the
yes, but I've given the attendance list, the copy of proceedings.
right. That has to be proved in the trial only.
Only.
Plea of LMI is required to be proved in the trial.
Yeah, okay. Do that officer will be discovered.
Petitioner is seeking quashing up for the criminal prosecution initiated against him. What is that FIR number?
FIR, Annex 1, my lord.
VR case
That's it.
number 8/28 of 2023 arising out of FIR number FIR number Purushottamapur PS case number 861 of 2023 for alleged commission of offences punishable under section 294, 341, 323, 506 IPC. The sole ground on which the petitioner is seeking quashing up for the proceeding is that on the date of incident, the petitioner was not present in the spot, and he spot. This is the attendance register. Spot. Are you a teacher?
Yes, my lord.
But he is working as a teacher. Which school?
Upper primary school.
Huh?
Project upper primary school.
He's working as a teacher in project upper primary school. Upper primary school?
Afasi Pada.
Afasi Pada.
Yes.
Afasi Pada. On the date and time of incident, he was in the school to support the same. He has filed the attendance register of the school for the month of December 2024.
Yes, ma'am.
2024. The plea of LMI taken by the petitioner needs to be established in the trial. Therefore, I am not inclined to entertain this petition because however, liberties can take to the petitioner to raise all the points of the trial court. So, still, with this liberty, the petitioner is disposed. And that's come.
Without following due procedures of law, without following the due procedures as stipulated in the court ballot. Fact is ballot, the present petitioner, Srimati Gayatri Pradhan, was DSWO Baleshwar. It is alleged on the month of October 2001, a tender call notice was published in the notice board, and there are some terms and conditions for the bidders. Allegation as per the vigilance is, though the work has been done.
Mr. Das, are you appearing in this matter?
So the work has been done, but without following due procedures, it was placed before the ADM, and ADM opened the bid documents on 27/10/2001 at around 4:10 p.m. in the office chamber in the absence of the collector, and it was ultimately placed before the collector, and collector passed it. There is the allegation. And the person who was allotted the work, he had no requisite
eligibility to
requisite materials to comply the same, but he has complied it in different way. My lord, my humble submission was, I am in no way concerned with regards to my case. I am submitting, my lord.
For Gayatri.
Gayatri. As DSWO, she has placed the documents, materials before the ADM for the approval, and ADM, my lord, an ADM had passed orders and it was placed before the collector, and the collector also approved it. And in that aspect, my submission was, it is everything.
Who is Kali Prasad Das? He is the ADM.
He is the ADM.
That is the
ADM.
first item.
You are the ADM. Okay.
ADM, for which my learned senior friend, Mr. Mahapatra, is appearing.
Yes.
My lord, I draw my lord's attention to the fact that it was everything on record and it has been seized, which was disputed by my learned friend. No, that has not been seized. That document has not been seized. But I verified from the seizure list that document has been seized. The records are also with them. My lord, I have got the Xerox copy. My learned friend must have got the copies which has been seized from the office. And seizure list clearly reveals that all the materials has been seized by Vigilance Authority in the course of investigation, my lord.
Yes.
My lord, serial number 4, my lord, let me see. The seizure list. 4.
Yes. One file AR number so and so for the year 1994-95. 51 sheets.
And my lord, that order sheets, their order sheets, subsequent order sheets shows it was placed before the.
Do you have the entire seizure in annex the seizure list 4? No, because see the seizure list 4, item 4, and 51 sheets in corresponding to so and so pages, so and so. Where are those pages?
Seizure list must have got.
Yes.
Do you have those pages?
In fact, I have got other materials indicating their complexity and there are materials to proceed. Apart from the order.
No, this what by law is very clear. We should not give any documents which are not part of the records.
Right.
That was my submission.
Right.
My learned friend says it is not a part of the record, but seizure list shows that they have seized it.
But that seizure list doesn't disclose what are the papers.
Yes, papers.
51 sheets and all.
Yes, sheets are.
It is only number of papers. That is only
a number of papers, sheets, madam. Sheets. I have got.
What are those papers?
Yes, papers is since my lord, it was placed before the ADM.
Tender file.
Tender file. It was there, madam. It is there. They have seized it. This is regarding.
It doesn't indicate whether it's a tender file, whatever.
Nothing.
See the seizure, item 4, you read it.
My lord, the file number is there.
Let him verify. Just Mr. Das, please verify it. See, those documents are not form part of the charge sheet, then at this stage they can't rely upon those documents. They are trying to build up their entire case on the basis of those papers. They say that it is form part of the charge sheet. Whether it is form part of the charge sheet or not, that is to be seen.
And bereft of that, my lord, if lordship permits, my lord, I'll just take 2 minutes, my lord. Bereft of that, my lords, there are materials, my lord. Lordship, what are the materials, my lord? I will indicate to lordship, which reasonably connects this both the petition of the lord and the alleged offense, my lords. And my lord, these materials are not being placed. All these, my lords, submission, my lords, can be termed as a defense plea, my lord, which can be raised the trial because it requires a proof, my lords. And these are all the materials not emanating from that charge sheet or the material produced by the prosecution at the time of consideration of the discharge application. If lordship permits, my lord, 2 lines, my lord. Now, then my lord senior to complete, my lord.
Let me.
Sir, please proceed.
I'll just submit my lordship's satisfaction. 2 pages of the charge sheet. Turn to my file, page 24 of my file. Page
24
of my file.
Yes, I'm there.
My lord, in third para.
Yes.
I'm just placing 3, 4, 5 para that will be sufficient, my lord, to understand. The
all
government
total 5 bidders.
My lord?
You are reading all total 5 bidders, that paragraph. The government of Orissa.
The government of Orissa. The Government of Odisha Women and Child Development Department enhanced the wheat grinding charges from 15 to 55 rupees per quintal, a supplementary nutrition program by Director so-and-so, dated 25/8/2001. With instructions to the collector, district magistrate of the district to adopt tender procedure for selection of mills to grind wheat for the purpose. Accordingly, the file was processed. The tender notice was published and the notice board with certain terms and conditions. All total 5 bidders participated in the tender. The bid documents are opened by the Kalika Prasad Das, ADM Paleswar, on 27/10/2000 at 4 p.m. in presence of the Srimati Pradhan, DSW, bidder Jayant Kumar Saw and Dhruja Rai. A comparative chart was prepared. Dhruja selected was L1 bidder for 54.45, and the recommendation of the Das ADM collector Paleswar approved the form and method. Accordingly, Dhruja Rai of Jail Road, Paleswar was issued order under the so-and-so proceeded with the grinding work. Subsequently, the Women and Child Development Department issued instruction to the collector with the districts to continue with the existing suppliers, SNT agencies and storage and transport agents under the different feeding program till issue of further instruction. Accordingly, Dhruja and enterprises grinded wheat from 2001 to 2005 and 6, submitted bills. He was paid 38 lakhs from 28/3 to 20 grinding of wheat and SNP. During the investigation, the correspondence file audit report bills submitted by the Dhruja Rai were seized. After repeated requests, the DSW Baleswar could not produce the bid documents. Proceedings prepared during opening of the tender, etc., and intimated that the bid documents which are under the custody of Ravinarayan Das, ex-senior clerk, are not traceable, and he has not handed over the charge to his successor. Sri Ratha also could not say how these documents were neither available in the file nor in the office. My lord, here is the point. The manager commercial FCI Baleswar intimated...
The bid documents are not available. Then how you say that we seized? Then the seizure list, item 4...
Then, my lord, that's a very funny part would be the next page, my lord. Kindly have a glance to the next page.
Page.
The executive engineer Baleswar intimated that the farm Dhruja Rai was commercial consumer on the electrical subdivision number 1 Baleswar, having consumer number 24866 dated 30/10/2011 with a load capacity of 15.5 used for grinding purpose. The electric connection has been disconnected on 1/10/2008. It proves that the farm Dhruja enterprises having no valid electric connection for wheat grinding till the date of opening of tender 31/10/2001. My lord, you are verifying in 2008. Connection supposed to be there, and you say in 2001 there is no connection. Disconnection made in 2008. And he attributes 2008 there is no connection.
Yes.
So
on
therefore,
further query from the
executive engineer electrical Baleswar intimated that in May 2002 to December 2005, Dhruja Rai consumed 25,774 units electric against the consumer number. On this, the AC cum Bhadrak EI collected the feasibility report of Dhruja and intimated that Dhruja Enterprises by consumer number so and so in SI category has installed one number of motor for grinding purpose. From the load data supplied to NESCO, it is ascertained that approximately 1.1 required for grinding 100 kg wheat. As such, Dhruja Enterprises has grinded total so and so of wheat single machine installed by Dhruja Rai. As such, Dhruja Rai received 38,33,500 towards the grinding charges and grinding of 61,175 quintals from 23 to 2002. It is a presumption.
No, it's carry on.
I'm coming.
This is charge sheet is to accept as true.
Coming, don't worry. Whereas he has grinded only 13.586. How come you say? Where from you got?
No, you get it clarified in the trial.
As consumption of electricity, because my electricity consumption is this, therefore you have grinded 13,000.
Next paragraph.
You cannot presume, my lord. You cannot presume that I grinded 13,000, not 61,000.
Let's turn to the last but one paragraph. Mr. Kalika Prasad Das, who is one of the petitioners, Baleshwar and Gayatri Pradhan, the second petitioner for lordship, have misconducted themselves by showing undue official favor by selecting this Dhruja Rai proprietor lots as lowest bidders, who doesn't fulfill the terms and conditions the terms notice for grinding the wheat under the that nutrition programs from 2001-2006, and thereby misappropriate 30,93,742. And this digit, you also can turn to the third on the top lots. Sir, sir, have patience. Have patience. I'm placing the charge sheet only, sir. I'm not arguing anything, sir. Sir, I'm placing the charge sheet, lots. But this visit, lots, which is the unjust enrichment, lots, and they facilitated these two petitioners, for this particular tender to get, it's appropriate 30,93,742, lot. This calculation comes by lots. Turn to the third paragraph on the top lots. That's after for grinding 13,586 quintals, of which he was supposed to get 7,39,757.
Yes,
quintals,
now
but he has
you
paid only
just tell me whether the
So this clear.
bidding process was wrong or right.
They are.
Bidding was correct, no problem. And he has not executed the work.
No.
That's the problem.
He has,
Correct.
he has not fulfilled the terms and conditions, my lords. And they are the persons, my lord, who facilitated them, my lords, so ignoring or fulfilling the terms and conditions, my lords. Where, my lord, that they, and my lord, if lords, you can turn to the last paragraph. Now, what are the charges, my lords? 468 for 201, 34. They also stand those who stand. They several persons with a common intention.
Let us see the.
They also serve. They do stand and wait.
Let us see the bidding documents which are.
My lord,
what are the required?
bidding documents, my lord was asking me this question whether it has been.
They don't have the manner. They don't have mechanism.
Let us see the bidding documents whether these are the condition. He might have outsourced also. By taking it, he might have grinded outside. Who knows?
My lord, at the time of taking consideration, my lord,
we are not
discharge application, my lord, many trial has not are prohibited, my lord. NIMS has not declared only prima facie case to
show me
the petition to proceed.
Please show me the bidding document.
I'll lots of fix it around.
That's the real issue.
Real issue.
Lordship, to appreciate one point.
No, there are materials, sir.
Just Mr. Das, wait for a moment.
I am waiting, sir. I am waiting.
FCI supplied me 61,000. I grinded, supplied back to the quantity to the collectorate 61,000.
How could you grind? You don't have mechanism.
Where from you got this 13,000? You can't issue a calculation on your own.
All the materials produced by prosecution has to accept as true.
Let me
And if you want,
bring the document.
Please the matter further.
Let him bring the record.
And
Entry
model is continued. Yes.
But when
He'll give a date. The bidding document, you show me the bidding document.
yes, that's all.
Yes.
First week or second week of
Second week. Yes. Second week.
entry order to continue.
Interim order.
The another accused, my lord, clerk, my lord, he is also another person, my lord, concealing all the records and all this thing, my lord. Anyway, my lord, I'll try.
See, insofar as bidding is concerned, you have no problem. You have given the bidding.
Agreed, your
It is a matter of execution.
It's a matter of
At the execution stage, you say that see, you have taken the bidding, no problem, but you have not executed.
You are
it.
not complied with terms and conditions.
Let them say
You
that.
put on the mechanism.
My
You don't
lord,
have
let them
infrastructure.
prove on record.
And how could
The bid
you?
was cancelled subsequently.
Yes.
Have you cancelled the bid?
No,
No.
because collector has approved it also.
Okay.
Collector approved and
Cancel
then
any
received the
can-
Why the state is not cancelled the bid?
Cancel.
What cancel? What has been
You tell me that also.
What
Why have you not cancelled?
money has been paid? How will we cancel it?
You ask him to still continue.
No. Another concern was assigned to that work.
Show me when have you cancelled the bid? Yes.
Another party was assigned to the same text.
Next. 25.
It's a Belgium matter, your lordship.
Yes.
Bail was granted on 17/3/2017. NBW was issued, your lordships, 21/6/2024.
Okay. High Court bar. Yes.
26.
Yes, my lordship, this is a Belgium matter, my lordship.
Yes.
The accused person was on Welch 4/7/2023 and the NBW has been issued on 8/1/2020.
Okay. 500.
37.
10th.
T02 is there, my CD member.
CD is not there.
Yes. Yes.
302 offense.
302.
Case diary is required.
Case diary. Call for case diary. Yes. Next.
Started my.
Yes.
28.
Listen, I am applying for the informal matter. I am already filed the Bhinam on 6 January, my lord.
It's all right. No problem.
Name may be reflected, my lord.
Yes. Name of informal to be detected. Yes. Next.
28.
Yes.
The petition is custody since 7/1/2023. The second time, your lordship, first occasion, lordship directed to move up after examination of material witnesses. Meantime, 6 witnesses have been examined, and out of which the 2 minors, son and daughter, they have been examined under PW 4 and 5. And a lordship, for a moment, with the deposition page 83 of the brief.
What is the last order?
Last order, page 68, your lordship.
What have I kept?
I have annexed the
Vital witness.
para 5, page 69. However, liberty.
Material witnesses. How many material witnesses?
My lord, your lordship's next page is the rejection order of this Lawrence Session judgment. Then para page 71, your lordship.
Page 71.
Madam.
Yes.
False so and so. It's much importance should not be given to their evidence. On the other hand, the postmortem report.
Where are you reading 71?
71.
Yes, 71,
Rejection
first
order of the session judge.
No.
The my lord, 1, 2, 3.
At the top.
My lord. The lordship is
Third line.
Yes, admittedly PW 4 and 5.
My lord, for being
these have
small
not
kids,
supported
they have also not supported at the time of 161. Much important. Thereafter, on the other hand, the postmortem report clearly reveals that the death was due to strangulation and there were some antemortem injuries on the person of the deceased. The mother-in-law of the deceased, who was present in the house at the relevant time, has not been examined, my lord. So, mother-in-law.
Why have you come? I have said the last time that let the material witnesses be examined.
Yes. 3.
There are other material witnesses.
2 and 4 and 5 will see the eyewitness to the present PW 5 is the eyewitness to the occurrence, the doctor. She has seen the mother was hanging, at page 83.
Who is the informant? Mother-in-law. Informant is the mother-in-law.
Father-in-law. They are not.
He is even examined.
No, my lord. ସେମାନେ ତାଙ୍କ ସାଇଡରୁ କେହି ସାକ୍ଷୀ ଦେବା ପାଇଁ ଆସୁନାହାନ୍ତି କୋର୍ଟ.
What of the doctor?
Doctor has also not been examined.
ସେମାନେ କେହି ଆସୁନାହାନ୍ତି. A lordship for a moment, page 83. Can I have a glance?
83.
My lords, the examination of PW 5 plus of daughter, lordship.
Yes.
The para 1, the informant happens to my maternal grandfather. This is Janaki Reddy was my mother, and accused is my father. My mother died on 1st January 23 in our house. She died early morning. When my mother died, I was reading in another room. She hanged herself in the ceiling fan of the middle room. My mother had given huge money to one Jhunnu of our village to get more return, but a Jhunnu fled away taking the money of the village. So my mother committed suicide. On that day, my father had gone somewhere outside to observe 09. Hearing sound, I rushed to the middle room and found my mother hanging. I immediately called my grandmother. Then we brought my mother down. Then my mother was taken to medical.
Yes.
This is the statement of the daughter, lordship.
To come to our house on 51. My mother was managing the father is very detailed, my mother. Yes. Next. The other witness?
The petitioner was not there in the spot, lordship. At the house, the 09 celebration are there. The occurrence took place on December 31st, lordship. And he was not present in the house, lordship. And PW6, lordship, the friend of the accused, lordship, he stated that along with him, he was there, lordship.
I read, I saw that.
Lordship. Yes. And the custody since one, lordship, 2 years above, lordship.
Custody from?
Custody from 7/1/2023, lordship.
7/1/23.
My lords.
Yes. 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 What do you have?
Well, the statement of the child witness pilot, your lordship, kindly see the postmortem report.
Yes.
That is
Postmortem
there.
report is
At page?
next question.
Yes, yes.
Page?
Postmortem is here. The next that is phase marking the proceeding.
56, lordship.
50?
56.
56, my lord.
Yes.
Relevant page at 58, lordship.
Yes.
That is due to strangulation and its complication that is there, lordship.
There are external.
But the eyewitnesses have not supported you.
Yes,
But
lordship.
one of the eyewitnesses, he was present, mother-in-law was present in the house, my lord. He has not been examined.
Where is her statement?
That is-
161.
That is the
161.
164, my lord. 164 recorded.
164 of
That mother-in-law.
mother-in-law. Show me.
Let me read it.
তুমি
ସେ ହଉଛି ଆର ଡିସିଜ ର ମଦର ମା
ନାଇଁ ନାଇଁ ଏଇଟା ଡିସିଜ ଡ୍ରମା
the what my learning senior is submitting.
one minute.
He has not been.
164 statement of the witness which has
ଦି
not.
ଜଣଙ୍କର
No.
ହେଇଛି ଆଜ୍ଞା ଦି ଜଣଙ୍କର 164 ହେଇଛି
କାର ହେଇଛି?
ରେଡି
ସେ ଡିସିଜ ର ମା ଆଉ ଭାଉଜ ସେ ଦି ଜଣଙ୍କୁ 164 ହେଇଛି ମାଇ learning senior ଯୋଉଟା କହୁଛନ୍ତି ଯେ mother in law present in with the child lordship she has not been made as 161 not recorded.
statement.
ନାଇଁ ନାଇଁ 164 ଟା ମୁଁ ଦିଟା
ସେଟା ସେମାନଙ୍କର।
ସେମାନେ ପଢି ଦଉଛି
ଡିସିଜ ର
They have been examined or not?
they have been examined
yes ହଁ ସେମାନେ ଏକ୍ସାମିନ ସେମାନେ
ଏଇଟା
ଆସୁନାହାନ୍ତି
ତ ମୁଁ କହୁଛି
Let them be examined.
ହଁ
ସେମାନେ-
medical witness not been examined
ସେମାନେ ଆଜ୍ଞା
The
spot
statement of the witnesses
Recorded not-
164 statement recorded.
my
Those witnesses have to be examined. They are maintained.
my humble submission would be that
That is the rejection order, my lord.
they are the
Tell me who-
they are the mother
One minute. Who are
my
they?
lord.
That is Chaudhary Lakshmi Reddy
Lakshmi Reddy,
and Chaudhary Raghunath Reddy.
Raghunath. Right.
Your lordship, they are the mother and sister-in-law of the deceased, your lordship. They were not present at the spot. The eyewitness is the present.
Can you please see my earlier order? What have I
Yes,
said?
your lordship.
What have I said?
Your lordship.
Let the material witnesses be
Yes, your
examined.
lordship. Yes.
And the witnesses whose statement under 164 statement is recorded,
My lord.
they are material witnesses.
Yes, they
Let
are,
them be examined. That's what
they are
I
not.
have said.
They are not turning. Your lordship may.
I'll
Yes,
give
yes.
direction.
Direct. The person.
Right. This is the second journey of the petitioner seeking grant of bail. Earlier, the petitioner approached this court by filing BLAPL number 6494 of 2024. This court, by order dated 23/9/2024, declined to admit the petitioner on bail. However, granted liberty to renew the bail plea after the material witnesses are examined. Total, how many witnesses?
Total 23 witnesses.
Out of 22 witnesses, five of them have been
23 out of 23, 6 examined.
6 witnesses have been. 2 witnesses, namely Lakshmi Reddy and Raghu Reddy, whose statements during the investigation under section 164 CRPC was recorded, has not yet been examined by the prosecution. Counsel for the petitioner submits that he will revive his bail plea after the said 2 witnesses are examined by the prosecution. He further submits that despite repeated summons to these witnesses, they are not appearing in court.
Yes.
Appearing in court. Regarding that to the aforementioned, although I am not inclined to entertain this petition at this stage, our liberty is granted to the petitioner to remove the bail plea after the aforementioned for named 2 witnesses are examined. The trial court is directed to examine, take necessary steps to examine the said 2 witnesses for the prosecution, preferably over all other witnesses. It is expected that the evidence of these 2 witnesses are examined and expeditiously, preferably with a period of 3 months. The petitioner is granted liberty to remove the bail plea. Bail plea after the examination of aforementioned 2 witnesses for 3 months, whichever is earlier. Okay.
So thereafter, the court below.
I've said that whichever is earlier. Yes.
My lord.
Yes. Next.
Your lordship.
कितने bail आ गया भाई? These bails are yes. Don't release the bail. Yes.
Section 302 and 34 IPC.
Yes. Then you have.
Your my lord, the 27 antecedents are 22 antecedents are there, my lord.
Yes. Yes.
Alleged occurrence.
Yes, sir.
The alleged occurrence took place on 4/4/23. In this case, 13 witnesses have been examined, including the eyewitness who are witness to PI parent, and they do not support the prosecution case. and one Rinki Deori also do not support the prosecution case and attribute overt act to this accused.
Have you seen the evidences of this witness?
Your lordship may keep it some other and also
I have
direct to
transmitted
22
the,
cases.
What about your antecedents? How many cases are there against you?
actually most of the cases
File an affidavit.
sorry.
Petitioner is directed to, the petition is directed to file an affidavit detailing the antecedent of the petitioner and the status of those cases. Release the matter after 2 weeks. Yes, next. 30.
May I please note? The petitioner, being a lady, is languishing in custody since 10/3/2024.
10/3/2024.
2024.
Okay.
Investigation complete. Charge sheet was submitted on 2/7/2024.
2/7.
My lords.
Yes.
Thereafter, the learned PO framed charge on dated 28/8/2024. Lords.
Yes. Yes.
The prosecution alleges, my lords, one Saroj Kanta Mahapatra and one Tanmay Kumar Maharana, both were manager and assistant manager of an IDBI bank, my lords.
Another case is your lordship shall speak to some other day. The manager of the output.
I am that subject to verification.
Verified.
I'll verify.
Please.
Your lordship, my request also.
Yes. Next.
May be called up along with it. Can I pray?
Along with you,
Same issue was there.
Yes.
But can I pray, my lords? Can I, my learned senior be directed to take instruction with regard to the health condition, my lords?
No, that is come. He was ill in this.
She was. Interim Jaithil Abhil Korparni at a.
Have you moved any application?
My lords, another IA is pending, my lords, for interim bail.
Issue notice on the IA for interim bail. Then counsel for the state to seek instruction.
My lords, press instruction.
Yes, press.
What's again?
Yes,
Next.
Instruction.
31.
Stated Jaithil Abhil.
Yes.
May I please, Lords? The allegation under section 302, 120B and 34 of IPC, my lord.
Yes.
The petitioner is custody since 7/6/2023.
7/6/23. Okay.
Charge sheet filed on 25/9/2023, my lord.
Oh. Yes.
In the last occasion, your lordship was directed the state to call for the deposition copy of the witnesses.
Yes, Mr. Jana.
Deposition copy
Nice.
ହେଇଥିଲା ଆର ଡେଟରେ କଲ୍ କରିଥିଲା ପିଏମ୍ ରିପୋର୍ଟ ଡିପୋଜିସନ କପି
postmortem report you can bring. But deposition copy ଟା ଆପଣ
ନାଇଁ ଷ୍ଟାଟସ୍ ଅଫ୍ ଦ କେସ୍ ପାଇଁ ଦେଖନ୍ତୁ ନୋଟିଂରେ ଆସିଛି ପା
instruction not deposition copy how
Radha Naik.
deposition copy
ରାଧା ନାୟକର ଆଇ ୱିଟନେସଟା ଯୋଉ
Radha Naik whether examined or Radha Naik 161 is there, my lord. But he has examined or not, he can say, my lord, because accused is always appearing
Yes.
before the court.
she has been examined, my lord.
Where is that
Provide the
statement?
deposition copy.
No,
Deposition.
Because he is the eyewitness, my lord. Your lordship is directed.
Do you have deposition?
No, my lord.
Then please after 3 weeks. Yes. Next. 32.
May I please, Your Lordship? Petitioner is a woman, my lord.
Yes.
Yes.
CD.
Yes.
My lord, the Honorable Counsel for the State has already been directed from
It's a time limit. It's last
16th.
last
My lord, 16/5/2024. They have already taken more than 7 months, my lord. Petitioner has been in custody since 10th November 2023, my lord.
10 November 23.
In the meantime, final report has been submitted and final form has already been submitted. Thereafter, trial is also commenced, my lord.
next week, as your lordship.
My lord, I have the deposition copies also.
What are the allegations?
My lord, 20B to C, my lord. The quantity of ganja is 51 kg, my lord.
51.
In this case, my lord, final form. In this case, my lord,
How many witnesses examined?
My lord, one witness has already been examined.
Only one. Charge sheet witness? How many charge sheet witnesses?
My lord, kindly see.
Check it up, how many witnesses are there?
Not there in the.
How many witnesses total?
My lord.
Total, how many witnesses are
My lord,
there?
3 witnesses, my lord.
In NDPS case, 3 witnesses only.
My lord.
Where from you got it?
My lord, kindly see the brief history of.
How many witnesses cited by the prosecution in the charge sheet?
My lord, 3 witnesses, my lord. Out of which one is already examined.
Show me from where 3 witnesses. It can't be 3 witnesses.
Exercise case.
Yes. One witness is has already been examined. Yes. Show me. What about antecedents?
No antecedent, my lord.
Rinku Bharti, yes.
My lord, kindly see a brief history of the case as stated by the excise inspector, my lord.
Jana, just check it up. How many witnesses? You have? Please check it up.
କିଛି ଆସିନି ସେ just ଗୋଟେ paper ଟେ ବର୍ତ୍ତମାନ ଦଉଛି ତା ଭିତରେ
No, no, certified copy. I have the certified copy.
1 week call for the report from the status of the trial, huh? From the sessions court. Which court is this?
This is
Ganjam. Where is that? Court.
Session Special Judge Ganjam at Barampur. In
Call for report.
UCC case number.
After 1 week, huh? Yes.
My lord, I got it.
After 1 week, I want to know the status of the trial because you are from Bihar. If there are 3 witnesses according to you.
No, my lord, 4 witnesses.
Even 4 witnesses.
One witness has already
been examined. Let us see how we will conclude the trial and give a direction. Yes, next.
He was examined on 18
Next.
2024.
Next item.
33. Pardon to make mention, Lords, item 30 with Lordships adjourned, Lords. Lords, the co-accused has been released on interim bail, Lords, my learned senior contended. His case stands posted to 12th of February.
12th February. Yes. Next.
My lord, kindly take it next week, my lord.
Yes, 33. Yes.
May I please, Lordship?
Yes.
My lord, the petitioner and the informant, my lords, are 2 friends who had gone to consume liquor, my lords. And one of the petitioner returned home, the deceased, my lords, his friend died, my lords.
Why was it adjourned earlier?
My lords.
Adjourned earlier, why?
Some relevant witnesses are.
Last order in Lordship may kindly see because Mr. Ponda has stated that almost the informant level stated that almost all the witnesses have been examined for that.
My lords, there are 31 witnesses, and till now only 12 witnesses have been examined, my lords.
28.
31, my lords.
28.
I'm
Out of
having
28 charge sheeted witnesses, 8 witnesses have already been examined. That's what I've recorded. Last time.
31, my lords.
21, who said then? 21.
31 witnesses are there.
Keep on increasing the number of witnesses.
31.
How many witnesses have been examined right now?
12 witnesses, my lords.
12.
And nobody has supported. They're saying that the present petitioner.
Yes. He is completed. Nobody has supported so far. He is in custody since. The same story. Both of you went. Had drink and he fell down. That's the story.
Your Lordship was inclined on
3/8/2023, my lords.
3/8/2023.
I'll say one thing, madam. Chain is complete. Last in theory, along with other evidence.
All right. Both of you went. Yes.
Hey.
None of them have supported the
So that
prosecution. Why should he be in custody?
And the motive is both are in drunken stage. They went together.
There was no motive. Both of them went, drank together. Sitting in a culvert and he fell down, it seems. Looks like he fell down, he died.
Yes,
he came and informed the parents. He died. What to do?
Mother told, you have called me.
Anyway, forget.
Madam, say one thing. let him impose some conditions, because in some cases it is.
What condition? He will appear in the court only. That is the only condition we
And
made.
also before the police station.
Why should he go to the police station? Trial is going on. Why should he go to the police
Last stage of the trial.
On a step.
Every day he has to.
Hello,
Right. Out of 31 charges to be taken, 12 witnesses were found. None of the witnesses have supported the prosecution. The petition is in 3/8/2023. The trial is likely to take place. No material has come on record as yet to support of the prosecution story. Hence, the petitioner is entitled to bail in this case. The grant bail in safe condition. Yes.
And every part of my submission be recorded only. Chain is complete. Last in theory.
Then for the complaint. On the contrary, submits that on the strength of the evidence of last scene,
Along with the other
petitioner is implicated, and apart from that, besides that, the other evidences is also there on record. According to him, the chain of the event leading to the crime is completed, and enough material has come on record to establish the complexity of the petition. Jana, appealing for the state, also submitted in the similar.
Lordship say last 28 is 31.
31, I think. Yes.
34.
Next week.
Adjournment on request, yes.
35.
Anti-mail lordship taken up 1 week after.
Adjournment on request, yes.
36. 36 and 37 can pass on.
Pass over. Hearing.
38.
Yes.
Custody is in 16/5/2023.
16/5/23. Yes.
Co-accused, your lordship granted bail, unknown affair. When the petitioner taken into custody, my lord, his own confession.
Yes.
And considering that 3 of the co-accused, your lordship granted bail. This is the last one, another 2.
Pradeep Sahu, who else?
Annexure 2 series, I have annexed, my lord. Ramo Raul and Raul Ponda.
Who are you?
I am Sibo Naik, my lord.
Yes. Have you seen it?
Need to be received. Yes, received. Received that. Because it
Received not, but you haven't read it.
Yes. Any other demand?
24.
the record.
24.
Yes.
Okay. Yes, next.
39.
I am for the informant. I am for the informant.
Nobody is there. What is the offense?
6 post-1.
Okay.
14-year girl was convicted.
24th of the 20. Yes. Non-APS part of the petition. Yes, next.
His lordship, lordship was pleased to issue notice on the my application for condonation.
One deceased.
Opposite party number 21 has died.
My lord, I will take steps for substitution of the OP2.
Opposite party number 1 is dated to 5. Whereas the service on opposite party number 3 admit. Service on opposite party number 3 is sufficient. However, service on opposite party number 2 is not effective. The petitioner is to take appropriate steps. Leave him out. Yes. Yes, next.
41.
Yes, madam.
In this matter, your lordship, 3 IAs are pending, 1 for substitution, 1 for setting aside abatement, one for.
This one issued. Service.
Yes, your lordship. I have subbed the copy also last
Have you-
year. Huh.
Huh? Appeared. Yes.
41 milers, I'm on my leg side, maybe pardon, I'm on VC.
Yes, yes.
They have served us a copy. Your lordship may allow the substitution. Your lordship may allow the substitution just for the sake of CMAPL to be heard, Milods. Because it's the same substitution has to be carried out in the second appeal again.
Yes. Then I'll restore the second appeal. Argue on merits.
Your lord, as your lordship, Milods, my only humble submission, if your restoration is be done, a reasonable cost may be imposed. That is my only humble submission. I will not object to that, Milods, of restoration.
No, you.
It was dismissed for default, Milods. It was dismissed for default.
Okay. Oh, the three applications, 138, 139, and 140. For the reinstating the application, PMLA. Then counsel for the opposite party submits that what is the delay? Let us see the delay application.
Delay of 8 years.
Delay of
8 years. 8 years.
In 2000, November 2015, they have died. They have made a substitution in 2024, my lords.
Around in view of the delay caused in bringing substitution of the opposite parties, cost of rupees 2000. Restore, huh? Restore. Yes. Allowed. Yes.
Grateful.
42. Service. Now make case for the parties, please the matter. We will take service here then.
43. Please notice. Does that matter? And let's say lordship's last order. Your lordship had asked, directed us to, permitted us to take some
Yes.
service
Are you appealing? Who is no, I'm with.
on the opposite party number 2.
Yes.
Now, when we filed an affidavit and also managed endorsement that by the sarpanch, the petitioners went with their staff, and she created a fracas there, literally whipped up a frenzy. Police had to be called. I filed an affidavit. That affidavit was new lordship record. So therefore, and she abused. Not only that, was abused in pre-abuse. Now, what do we do in this circumstance?
The only thing is we accept it to be.
Accept the service to be sufficient, and your lordship may place a date, fix it on a particular date for hearing.
Where is that affidavit? Have you filed the affidavit? Where is that?
We filed an affidavit. Yesterday.
Yes. The affidavit, the vesting notice. Party by order dated 7/1/2025. After effecting the service, the petitioner have filed the affidavit of service and dated 26. No. What is the date? 20th. For the reasons stated in the affidavit, the service of opposite party number 2 is taken to be sufficient. These the matter for final disposal.
Second week, short matter.
Second week.
Service dispute, it has snowballed into a litigation.
Who will dispose it?
Grateful. Interim orders to continue.
Interim order to continue.
Grateful. 45.
Pass over, man. Pass over. Service sufficient, na? Service sufficient. Pass over. Let us see. We may come.
Pass over, man. After launch.
Pass over, yes.
6.
May I please, your lordship? Firstly, in this case, notice has been issued, but the lordship may see that arising out of complaint.
Huh?
This is an efficient address.
If your lordship may fresh notice or your lordship the similar case, like the present
No, no,
from other case.
services.
If your lordship may see. Fresh
Service on opposite party number 2 incomplete due to the insufficient address given by the petitioner. Then consequently the petitioner seeks an adjournment to take necessary steps.
Fresh notice with correct address, my lord. Fresh notice with correct address.
Notice.
At the lordship. Great.
47.
Service to sufficient. Huh? Sufficient. Also,
48.
There are batch of cases. In fact, I am appearing in the first case.
Yes.
Lord, here, one thing has happened, my lord. There was death of opposite party number 9, and steps were to be taken for substitution in respect to all the cases. Opposite number 9 in all the cases.
Opposite party.
Already
Opposite
filed.
party.
Notice has to be. So notice has to be.
I think
Party number
if your lordship will.
necessary statements to be taken.
State is also petition over the case. আমাদের petition দেই তো দেখুন এটা কো কেস ফাইল হয়েছে
All the matters,
all the matters, in fact, in the first case also, an application has been filed, that is miss case number 310 of 2013, way back in 2013, for substitutions in the review applications.
200?
310 of 2013, that is at flag Z. Flag Z.
310. This is regarding
Substitution.
substitution of which
Opposite party number 9.
9.
Yeah.
In what about the other
They are also 9, same person.
applications are moved? No.
Yes. in
Yes,
all
here
cases.
also I find that office notice substitution petition filed in almost all cases.
In all the cases you filed.
There is some defect.
No, this is first case I am appearing, I filed an application already. that is-
Aji.
No, good day.
See, write down. First case, miss case 310 of 2023. Opposite party.
Lots of you permit us, I can take notice to the
Paramananda Das
proposed legal representative.
has died on 15/7/2012. Leaving behind legal heads to represent legal heads. Died and so on. Therefore, the petitioner had moved the represent application seeking to implead the legal representative for respondent number 9. For the reasons stated in the application, the same is allowed. The LR of respondent number 9 will be alleged party. Of respondent number 9. What about the other applications? In all the petitions filed?
I hope all the cases are same, but I am not the counsel there.
No, I am also counsel for 1 and 2, not others. Where the opposite party?
Nobody.
Substitution नहीं
Substitute.
No applications in second matter.
नहीं miss case number 265 of 2013 at flag X in the second case.
We'll check it up. Wherever there is,
That's
we'll allow.
That's right.
And wherever it's not there, you move up. Huh? Take it up.
All the review applications. Notice on the question of limitation was to be taken, no steps have been taken. That is 2015 review.
No, say that.
Okay, I'll pass you.
Anyway, that will be hard. That is a different question. But for those who are already ready, only notice has to go to the legal heirs.
Legal heirs. That's right. Yes. You need to legal heir application fill कर दो, notice कर दो. Yes. Yes.
49.
49 may be taken up next week. In this case, I will file a additional affidavit today. Taken up next week.
On request, yes. Or to can you or go to me?
51. After 52. Yeah.
I'm praying for quashing of the entire proceedings, basically on two grounds. Your Lordship may kindly see the complaint fiction at page 11.
Yes. Who is appearing for opposite party? Notice was issued. Not there. Last
Your
time
Lordship
also,
had substantially heard last occasion.
Mr. Ragada appeared.
Madam?
Mr. Ragada appeared.
No, this is not that civil.
No, his name is there.
I don't. Mr. Das was appearing last.
But pass over. He may come. He may come.
After lunch,
It may come. I don't know.
after lunch.
Shall I adjourn it?
No, my lord, I'm ready. I want to finish it. Your Lordship had heard, your Lordship may kindly recollect. There was a negotiation of for selling the property. Property stood in the name of the father. Father alienated the sale, property. Sale deed was executed. The record of right corrected. Thereafter, the complaint petition was filed that delivery of possession has not been given. Your Lordship knows under section 47 of the mutation manual, unless possession is coupled with the delivery, the execution of sale deed, the mutation cannot be allowed. So mutation record having been corrected in his name with valid notice to me, and I have supported the mutation.
No, what is the grievance, sir?
The grievance is that the possession has not been, that has to be decided in civil court. Can a criminal case be filed against me? And I was arrested and I am a doctor, registered medical practitioner. I was put in bath for 15 days.
Okay. Then it needs to be heard. Sure. Simply none appears for the opposite party number 2. Lease the matter for hearing, second week of February year, and interim order to continue. Okay. Yes.
After the ROR has been published in his name, what remains, man?
Yes.
Item 47.
47.
Due to some leave.
47.
Passover exam?
Passover. Somebody asked for Passover. Can you mention?
For item 12.
May I please, your lordship? The petition filed under section 228 BNSS for dispense with personal attendance has been rejected by the trial court because the present petitioner is a assistant teacher also in charge of the headmaster of a residential school specially made for the SC/ST categories, my lord. And the victim is the cook in there. She alleges and lodged an FIR on that page 70.
Page 70.
It starts from 69, that is order dated 6 November 2024.
Well,
NBW is still there.
NBW, okay, right. Petitioner is agreed by the order dated, which is the impugn order?
That is, impugn order is, my lord, here, both. That is 28/11/2024. That is starts from page 72, 9/12/2024.
72. Petitioner is agreed by the order dated 28/11/2024 passed by the special judge Gunpur in TR number 117 of 2024, whereby his application under section 228 of BNSS for dispensing the personal appearance has been turned off. The petitioner submits that the petitioner is working as a
Assistant teacher in a residential school of government. Classroom school that is being maintained by the government.
Physical presence in the school is necessary, therefore he cannot appear in the court on his date of hearing. Hence he moved the application which has been turned on by the trial court. And counsel for the state, on the other hand, submits that the petitioner has been outstanding. He is facing a serious charges for at least commission of offences punishable under section 64(2)(f) oblique 75(1)(I) oblique 75(1)(III) and 351(3) BNS. Read with section 31RS and 3WI and 32VA and 32V for SC/ST PO Act. Therefore, his application under section 228 of BNSS has been rightly turned down. I have perused the proceedings before the court below and court below. It appears on 8/11/2024, while rejecting the application for the petitioner for dispensing the personal appearance. The trial court issued NBW against the petitioner. Mr. Das, let counsel for the petitioner on instruction submit such a client would be appearing of the surrendering before the court below on or before 15th of February 2025 and resort to the remedy available to him under law. The execution of NBW issued by the special judge Gunpur by order dated 8/11/2024 will stay till 15th of February 2024, subject to petitioner surrendering only appearing before the court below and resorting to the remedy available to him under law. With this observation, the petition is dismissed. Yes. Next.
36.
Yes. You are appearing? Yes. Yes, sir. Yes.
207 kilometers going down.
You have?
Yes.
Okay. They are in the corporate in 25 February 2023.
25 April.
February.
February 23.
23.
Okay.
Out of 9 witnesses, out of 11 witnesses, 9 witnesses has been examined.
Out of 11, 9 witnesses again.
And they all independent witnesses has been turned hostile. Has been turned hostile.
Okay.
Out of them, one is the driver.
Out of 11 witnesses, 9 have been examined. Wait for some time.
Out of
Trial
16
will be concluded.
Out of 16 witnesses, 16 witnesses.
16 witnesses.
9 has been 9 has been examined. Bit of 6, 7, and 8.
I'll ask for the status. of the
Contrast
trial.
position.
Ask. They take status report from the trial court. Next, please sit.
6, 7, 8.
I'm seeking a status report from the trial court. What is the status of the trial? Okay. After 2 weeks. Right. Yes. Next.
37. 37.
Correct.
Same. 37 on 28. These are the status report of the status of the trial from the trial. Yes.
45.
Yes, sir.
Please, my lords. This is with regard to 143A NI Act, my lord. Your lordship, on the other day, after hearing, was pleased to issue notice, and notice perhaps have already been solved on the
service. Sufficient. Yes.
Now,
Somebody
but I
appeal
beg to
for-
say
Yes.
that the
What is the check amount?
check amount is 9,90,000, madam.
Yes.
So claiming 20% of the compensation, he has filed an application. And the application was rejected by the page 20. Your lordship may kindly glance.
Yes. You are the complainant.
I am the complainant. In the instant case of perusal of the record, it is seen that the.
Where are you reading, sir? Where are you reading?
Page 20.
20. Yes. Yes.
Paragraph 4. That is the impugned order, man.
Connecting
The ground was rejection. Ground of rejection, it mentioned that in the instant case of perusal of the record, it is seen that the complainant has filed this petition, present petition, instead of adducing evidence when the record was posted for evidence on the side of the complainant. Thus, this court is of the opinion that the complainant has not been able to show that the accused is deliberately avoiding or is causing undue delay in trial. That happened, no specific reason or cause has been assigned in the petition on section 143A. Therefore, under these circumstances, this court feels that the said petition cannot be allowed. The statute says something else.
Yes.
And for information.
What
of
is the stage now?
Stage, my lord, it is for trial, and evidence affidavit has already been filed after charge.
On your behalf.
After,
On
my
your
lord.
behalf.
So this observation is, my lord, is wrong.
Wrong observation.
No, my lord.
I'll set aside and send it back for reconsideration.
The statute itself.
I know, therefore I'm setting aside and sending it back for reconsideration. Right. The petitioner is the informant. Petitioner is the complaint in the ICC case number. Where is that ICC case number? 466 of 2023. 23. Filed under section 138 NIA against the opposite parties. He moved an application under section 143 capital A of NIA for grant of interim compensation pending the trial of the case. The said application has been turned down by the impugned order dated 31/5/2024 by the learned SDJ S. Cutters. Hence the petitioner is aggrieved and has filed the present petition. Notice was issued to the opposite party by the order dated 22/11/2024. Although the service is sufficient, but none has answered the opposite party accused. When counsel for the petitioner has taken me to the impugned order, operating part of the impugned order is reads as what is 20 para 4. He submits that the reasoning for rejection of the application under 143 capital A as has been observed by the trial court is that since the accused is not deliberately avoiding the proceeding and causing delay. Therefore, the application under 143 is not liable to be allowed. And counsel for the petitioner, by extensively reading out the provisions, submits that this is not the required consideration to be dealt with in application number 143 PMLA. I'm in completely agreement with the submission made by the petition. Hence, allow the petition, set aside the order, impugn order 31/5/2024, passed by the learned HCGN S. Cutter, Sadar Cutter, and direct the trial court to decide the said application afresh on its own merit, on its own merit, without being replaced by the earlier observation made in the impugn. With this observation, petition is disposed. Yes. Yes, next.
Strictly to the provision of 143A manner, because the finding is contrary to the provision.
Yeah. Yeah, next.
47.
It's not taken on next week because road side last occasion issue notice to the opposite parties. But why got she changes the address? For that reason, I want to take notice in a new address for new payment.
Huh? Notice is sufficient.
No?
Notice is sufficient.
Yes, yes. But another person hasn't received, but he has not, she is not received.
Who? There is only one.
Next week, amendment करके new address टा दे दे बिचारा.
Notice is sufficient. That's what the report is.
Yes, but she has not received. For that reason, he has not appeared today.
Okay. Counsel for the petitioner submits that the opposite party herself has not received the notice, and he wants to take the first step for serving her once more. Leave the matter after 2 weeks. Yes.
Next week and
Yes.
early in the meantime.
51.
Yes.
Made this arises out of a protest petition. The FIR was lost by the D. Outraging of the modesty.
Yes.
She belongs to Scheduled Castes and Scheduled Tribes.
Who is appearing?
I am appearing.
Yes.
The petitioner is a police officer. The allegation is initially the FIR was investigated.
Closure report ended up with a closure report. You file protest petition.
Yes, sir.
They file protest petition and
your lordship sees the impugned order. But very interesting conclusion, that is page 28.
Yes.
Order dated 16/2/2006.
Yes.
Well, your lordship, I am placing from 29. The word cognizance is used in the criminal procedure code to indicate the point when the magistrate takes judicial. Last paragraph. Taking cognizance. That then page 30, it is the case of the complainant as stated in her initial statement recorded under section 200 CRPC and evidence of other witness recorded under 202 CPC that the complainant had gone to the Chandni Post PS to report about the theft of her vanity bag. But the YC of Chandni Post PS had outraged the modesty of the complainant and molested her by rubbing his hand on the back of the complainant, and also it is also alleged by the complainant that the accuser told her so and so, and after which the complainant felt humiliated and left the PS. It is the case of the complainant that she had gone to
Banaigarh to lodge a report against the accused before the SDPO of Banaigarh, and SDPO duly received the report of the complainant and told her to come on the next day on 15/5/15 to Chandni Post PS, and again on 15/5/15 the complainant went to Chandni Post PS and her statement was recorded by the SDPO, and again she was told to come on 16/5/15 to office of the SDPO at Banaigarh. And again on 16/5/15, when the complainant went to the office of the SPO, she could not be able to find him and came to know that this had gone to Raurkela to the office of SP Raurkela, and subsequently the complainant had gone to the Superintendent of Police Raurkela, and the SP Raurkela had advised her to lodge FIR at Mohalla PS Raurkela.
Yes.
So Mohalla PS Raurkela has registered the FIR such and such. She looked at and the DSP Raurkela investigated the matter. Has your lordship got it?
Yes.
And submitted final report. There is every possibility. This is the reason for taking cognizance. Every possibility that the IO in the GR case, that is the DSP, has overlooked
the examination of the material.
some material witnesses, as the accused is a police officer, and there is chance of biasness on the part of the IO.
Leaving that apart, let us see what is the protest petition and the initial statement. If any case is made out. Those things are regarding the investigation part.
Yes.
Investigation may be biased, whatever. Concluded in a final form.
He has not discussed the initial statement and the earlier statement recorded.
Then if it is made out, otherwise I will have to set aside and send it. Again, the cognizance will be taken up. What is the use of it? Let us see if the statement, initial statement, if any case is made out. Come to page 20.
Yeah.
This is the initial statement.
What is all that? Initial statement. Page 20. Next to page 20.
Yes.
On 14th May 2015 at about 8 a.m. I had been to
The same thing which we have read out, everything is narrated. Same, exactly the same. Narrated. So in that situation, how will you find wrong?
My dear lordship may see the earlier charge sheet, the closure reports. Well, there must be some reason.
The reason is the
initial
202 initial statement and the protest.
Well, your lordship may look at page 34.
34. Okay. Yes.
During paragraph 2. Has your lordship got?
34. Okay. I got it.
Page 2. Paragraph.
Yes.
Second paragraph.
Yes.
During sentence beginning with during investigation. Yes. During investigation, I have examined the complainant, visited the spot at Champacharan temple as well as Chandni Post PS, examined the witnesses at the spot, and it is transferred that the priest and the shopkeeper present on the relevant time and date could not notice anything wrong with the lady. Though the lady was working at the temple side, neither she had offered puja nor complained for help against her snatching. Later, she arrived at Chandni Post PS at about 10 a.m., where she alleged to have been outraged by Umakanta Naik. But by examining the other staff inside and outside PS and local market, it is found that the complainant, after getting down from the bus, charged her mobile such and such in the clinic of Sisra Biswas and talked to a few persons and came to Chandni Post PS, where she talked to sentry constable and homeguards present. Subsequently, she made the in-charge officer, SI Naik, talk to her after being allowed to sit on the chair. The sentry constable was present there very well. After taking, she went back.
That is the reason he is dissatisfied. Come to page 14, para 4, in his complaint.
Just 1 minute. She didn't complain about it, but didn't from the investigation. Has your lordship got that? It is found that she had talked as many as 32 times to one cell number such and such is being used by one Rajendra Munda, reportedly her farmer, who was arrested in Lahonipada PS case number such and such. It was presumed by Munda that SI Naik became instrument of his arrest, and therefore this is a first aid case.
See, the investigation, she was not satisfied. It is a case of 354.
Yes.
Therefore, he filed a protest petition.
Yes.
Come to page 14, para 4. He narrated the entire incident and he said that the police has not properly investigated. So therefore, he filed a protest petition and laid evidence under 202, making specific allegation against you. Therefore, the cognizance is taken. There's nothing wrong in it. Absolutely correct.
Everybody can be prosecuted.
That's right. That's what to do. It's a cognizance thing.
Yeah.
Cognizance thing.
But
And you are a police officer.
that is true.
So therefore, you are a police officer. There is all possibility that you might have influence. I don't know. But that will be established at the trial. That may be your defense. But how will you find fault with the cognizance order?
The cognizance cannot, it is not a mechanical thing.
No, he is. It's not, absolutely, it's not mechanical. Very specific allegation.
And to throw down the entire investigation earlier conducted on the ground, there is a possibility that there will be bias and other things.
Therefore, he say in the complaint, it's very meticulously drafted complaint case. Very meticulously drafted. And para 4 and 5, just see.
Yes, I have seen, Milord.
But then how will you get out of it?
Didn't investigate into the matter.
I think you argue at the stage of time.
Who is the material witness? He says that he didn't examine the material witness. All those present in the police station.
That is the reason the provision of protest petition, if it's not satisfied, it is a case of outraging modesty of a woman in the police station by a police officer. When she went to give a complaint.
She made a statement that I went to the temple, but didn't go. Straight away got down from the bus. Charged his mobile in some statement. Those persons all antecedents.
Anyway, I think you should argue in the stage of charge.
That is consistently your lordship is telling. But there are certain cases, you know, where your lordship.
On facts, you have a very bad case. On facts, you don't have a case. Is there any legal issue? You tell me.
But
I can deal with that legal issue. But on facts, you have a very bad case.
This paragraph 4 and 5 read together that the police officer didn't examine material witnesses. Who are the material witnesses?
That is how a complaint can ventilate his grievance in a protest petition saying that investigation officer has not done properly. And particularly when an accused himself is an accused police officer.
Orders your lordship is passed. I am not reading. I am just making a general submission that somebody says that material witnesses is not examined. He has to prove who are the material witnesses are not examined, and he is examining it now. Those things are absent totally.
But the 202 statements are very telltale. I'll pass the order. Yes. Okay. Yes. Next. Happy Dido. Yes.
53.
Wait, please. Here, my lord, challenge the order passed by the land estate under Annexure 5. In this case,
ready. Yes.
Lordship, small request, Lordship. In the present case, there are altogether, in the 1CC petition, there are altogether 3 accused persons. Altogether 3 accused persons.
Yes.
The present case is confined to 2 petitioner, Lordship. So far, the other petitioner is concerned, the case is pending in another court, Your Lordship. All the cases may kindly be taken up together.
Give the number.
Yes, Your Lordship.
That is 482.
Yes, Your Lordship.
That has to come to this court only.
Yes, Your Lordship.
Take the number. Insofar as the third accused is concerned, he has filed CRLNC number so and so, which is pending in the court so and so. At least the CRLNC so and so, along with the present petition on such and such the interim order to continue. Yes.
On 7th.
We'll give it. Yes.
Second week.
Second week of lecture. Yes.
Interim order to
continue. Yes.
4.
Yes.
This matter relates to this students who are agitating before this office, and there are 2 petitions. One is filed individually, another is a group of students. And my senior is appearing for the
CBS, Board of Secondary Education. Board of Secondary Education.
Yes.
And
but there is opposition. Serious opposition.
His opposition. The case, my lord, there is a agitation of the students and there is allegation of assault the officials, but the president himself, herself given.
I think time heals so many things.
Yes.
So since an interim order is there, let it. I'll take it up for second week. Let it. Time may heal.
Well, another matter is there. Let it may be taken up both the matters.
Both the matters. Interim order to continue. List it for disposal. Second week.
Second day of this month.
Give little time.
Yes, my lord.
They are students. In fact, they are students.
About the other students, I don't know. Only one person is there who is got a job because of this. He is facing problem. That's why I.
Anyway, you people are RSS. Karyakartas.
So, my lord, Kennedy date will be fixed.
A date will be fixed. Interim order to continue. Fix it into second week or so. Give little time because his client, right now he is not agreeable to you, but I think time will heal. Yes.
Even the evidence is going up. Our witnesses are going and posing.
Well, may I, one thing, let's see, if there is a witnesses that we examine, because stay is there, interim order is there, no objection.
Why, if they stay, how the trial court is?
Yes, they cannot proceed, no, that's what the one.
There is no stay of trial.
Let's make life the
trial means.
Why are you, sir, why are you aggravating it? Why? There is no point precipitating it. Let it be stayed for some time. They are students. They are students. Why to precipitate?
Because my friend, it is in his advantage, the stay should not be there for trial because he is bringing the depositions and showing as if there is no case is made out.
Okay, then.
So what I'm praying,
you are able to.
What I'm praying, my lord.
Yes.
If there is no bar to getting the watching the trial, if by the next date, let's see, may observe this also. Otherwise, let them trial be concluded.
I didn't follow. What do you want exactly?
But and that suppose some trial is commenced. If any trial is commenced, that let me continue.
Continue. Who says?
That may be clear. They are not doing this because of this.
It's continuing. It's continuing.
Continue.
Then my lord is correct. My senior is correct. Yes.
I make clarified.
Yes.
Where is that interim order? The interim order passed on 14/8/2024 by this court shall not preclude the trial court from proceeding with the trial.
Yes.
Proceeding with the trial.
Suppose any development will learn, it can be helpful to us.
Okay. You will be acquitted by that time. Yes.
Sorry,
you take the witnesses and
yes.
examine and finish it up. Yes.
I am in 55 for the opposite party, Your Lordship. Perhaps time has been taken. I have not been given consent, Your Lordship.
No, somebody mentioned. Okay, adjourn. Yes.
56, the melody 56, the OP number 2 has entered into appearance and my opponent has appeared. It is not for time to filing the counter.
You file counter?
Right.
Yes, ma'am.
Printed appearance for the party and 1 week time to file counter. Let him do so. Lease the matter.
My lord.
Yes.
One more grievance, my lord, the interim order which was passed earlier, my lord, let it be modified, the date may be extended only.
Date may be?
Extended. I was directed to surrender on or before 15/12/2024.
No, what is this matter is about?
Matter is, my lord, challenging an order passed by the London Court below rejecting an application where I am the accused in that case, that is the NI
138 NI
Act case. In that case, I made an application before the London Court below that the report which was received by the state laboratory should be sent to the central laboratory. That was rejected. That is my limited grievance.
The NBW was issued.
Yes,
I have cancelled it.
My lord,
come on. Okay. Let us see on merit whether you have a case. In 138 matter, why should it be stalled like this?
Yes, my lord.
No, my lord.
And the complainant is a senior practitioner of this bar.
And but you are asking time what to do?
My lord, as because I couldn't submit the affidavit, as because the complainant or
Let us see what
party is severely ill. That's why. That's why I
you are
sought for
asking time. Why I can't help it?
Mine.
I can't help it. If you
That's why I sought for
ready to
time.
argue, then it's all right.
Within 1 week, I will file. As because he's unable
Leave
to.
it after 1 week. Yes.
Until then, my lord. Interim order. That is
Interim order. What is the interim order?
interim order. I will surrender and that.
You surrender.
which was
You surrender.
issued.
No,
My
my lord, he's regularly avoiding to appear in the court.
No.
Since 2 years, the NBW is issued.
No.
And
The
nothing is
NBW
happening.
was issued only on 30th August 2024.
24, no?
Yes.
23.
No.
ଦେଖନ୍ତୁ ଆପଣ
That was NBW.
NBW was issued.
White order dated
He is not appearing.
2024. The petitioner was directed to appear before the court on or before 15th December 2024. He seeks an extension of time. The time is extended up till 5th of February. And the execution of NBW issued by the court below, white order dated 30/8/2024 is stayed till 5th of February, subject to petitioner appearing before the court, appearing before the court on or before 5th of February. Release the matter after 5th February.
Minus.
Lovely.
7th.
I'm appearing for the opposite party. Let him serve copy of the petition. Let
So entered appearance for opposite party and submits that he has not received the copy of the petition. Let us for the petitioner to supply the copy of the entire petition. Leave the matter for him. Yes.
next week,
on behalf of Mr. Suraj Manti, learned counsel for the petitioner, an adjournment is sought. Leave the matter. Notice on the opposite party is sufficient, but nobody has entered appearance as yet. Leave the matter for hearing interim order to continue.
59. May I please, your lords? The petitioner challenging the order of cognizance taken by the learned court below in 1CC case number 286 of 2023.
286
of 2023. Annexer 2. Annexer 1 is the order of cognizance.
Yes.
Page 11, your lords.
Yes.
12/3/2024.
Yes.
But
revisable order.
Huh?
It can be revisable before the appellate court, my lord, district court.
No, I'm telling the entire proceeding, my lord. 1CC proceeding which arises after I have filing the 1CC case under section 138 of NI Act. But after filing of that, the petitioner first filed this case, implicating me as an accused. That at the time when he was entered his house, I have obstructed him and snatched away his bike and used the fifth language. He has filed the complaint petition under section 120B, 341, 323, 379 of IPC. However, the learned court below has taken cognizance.
Why should it be quashed?
My lord, there is no point arises to file the complaint case because after filing of the 1/6 case, in Negotiable Instrument Act, they have filed this case in falsely.
How will you infer that from this? From the complaint, how will you infer that after you filed 138 case, he has filed this as a counter? How will you infer?
Well, Lord, you can see Annexer 4.
4.
Yes, Lord.
Yes.
My complaint case is filed on 29/4/2023.
Yes.
And he has filed his complaint case on this Annexer 2, Miller. 11/9/2023.
When you filed the complaint case you filed on
29/4/2023.
29/4/2023.
I have filed.
Yes.
He has filed on 11/9/2023 after 5 months.
After 5 months.
Yes.
How do you say that it is
In that case, the notice has been gone and he has appeared. contest the case and to discard this case is like,
See let us see the complaint. Yes, see his complaint. What are the allegations?
Page 2.
Yes, come to page 14.
14, yes, ma'am. Brief facts of the case that the complainant is an innocent and law-abiding person and the accused person are antisocial type of people having no respect towards the law of land and accused to carry out liquor business. That the date, time and place of occurrence which is described in column 3 of this petition. When complainant came to his house through Hero Glamour motorcycle bearing number such and such with Vidhara, witness number 2. Suddenly above named accused person along with 2 other persons arrived in front of the complainant and wrongfully restrained the
Let us see the evidence. 202 statement.
evidence at page 16.
Yes.
Let's see. Page 16.
Read it and come to page 18.
18 units. Yes. Deposition with witness number 1 for the complainant is about 50 years, such and such.
Read the relevant part.
Para 2, on that I along with my brother were going to our sister's house. In complaint, he has said that in his house. He has stated that in sister's house. On the way, the accused Porta obstructed our glamour motorcycle and abused my brother in options language. The accused asked my brother to why he did go to his shop. Then the accused Prasad along with the other person assaulted my brother and then the accused took the motorcycle of my brother bearing the registration number such and such.
You argue at the stage of framing of charge, nothing. Because complaint he has said something and in the statement also he is making allegations only at this stage. Cognizance is rightly taken.
That's in the act which has been stated in the complaint.
I can't appreciate the statements at this stage. If it's apparently something I can understand. You abuse, obstructed them, all these things are there. Cognizance is only taken in the complaint case. You go and argue that petitioner is agreed by the petitioner is seeking quashing of the order dated 12/3/2024 passed by the SDGF Kendrapada in ICC case number 286 of 2023, whereby cognizance of offences punishable under section what are the where is the order? Impugn order?
Order is impugn order under Annex 1.
No.
Next week, I'll
under section 120 capital B /341/323 /379/34 IPC is taken against the petitioner. I perused the complaint filed by the petitioner submits that he had filed a complaint under section 138 NI against the opposite party on 29/4/2023 after receiving notice from the court in the state complaint case as a counterblast. The present petitioner is the opposite parties have implicated the petitioner in the present case by filing a complaint case. Hence, the trial court has not appreciated the facts of the present case, rather mechanically taken cognizance of the offences. I have perused the copy of the complaint based on record as Annex 2 and the initial statement of the complainant and other witnesses recorded under section 202 CRPC. I am of the view that the trial court has rightly taken the cognizance of offences as a prima facie case is made out from the narration of the complaint, from the narration of fact made by the complainant, opposite party in the complaint, and supported by the preliminary statement recorded under section 202 CRPC. Hence, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all the points before the court below at appropriate stage. With this observation, the petition is disposed. Next.
last occasion receive also issue notice to the opposite parties. Also, his entered appearance, name is there, my lord. What happened in this case, my lord? Initially, complainant, who is the opposite party here, my lord, filed a complaint petition, which was subsequently referred under 156, registered as FIR. And in this FIR, final form submitted is a false, FIR is false. Kindly page 19, my lord.
19?
Page 19.
Yes.
That during course of investigation, it comes to light that the complainant petition, Shakti Prasad Swami and alleged accused Sankhalata Barik are of the same village, such and such, under Sukina PS Jaspur. Shakti Prasad Swami got married to one Sarojin and blessed two child daughter. On the other hand, Sankhalata Barik got married to one Guluri Barik, son of Etiki, and maintaining and a happy conjugal life. Prior to the marriage, Sankhalata Barik, there was love interrelationship between Shakti Prasad Swami and Sankhalata Barik. Hence, after marriage of Sankhalata Barik, to depressed her maternity and to put them in problem and to restoration in our conjugal life, and as dragged before them before this honorable
Why don't you
court.
file a typed copy of it? You are struggling so much.
Yes, for that in final form has been.
No, I'm asking you, why don't you file a typed copy of this? Typed copy of this page 19. Nobody can read it. You are struggling here.
I'll
Now file it. Right now. Federal Council for the petitioner submits that he would be filing the typed copy of the charge sheet by next date of hearing. Non-APS for the opposite party despite service in the interest of justice. Adjournment is also interim arrangement.
Interim order is there.
Continue. Yes.
61.
Yes.
May please your lordship, my lord. Well, in the case, my lord was kind enough to take directed to state council to take instruction.
Yes.
Yeah. Case the case arising out of the passing of cognizance, because the entire prosecution is a texture of civil flavor. Because the allegation is that the present petitioner sold one parcels of the joint family property.
Yes.
And thereafter, the joint with the co-partners filed a suit challenging the sale. And in that case also, the present informant also made party and filed WS contesting that the sale is good. Apart from that, my lord, the very case is arising out of complaint case. Complaint case straightway paying for under section 156(3) for registration FIR, as your lordship knows, is regarding law. Therefore, my humble submission, when the
why have you not implemented the informant?
Here, my lord. I mean, because it is a GR case, so I will.
But you implement it because you say that it is a civil case, basically. Implement the
in the meantime, the informant died. The informant public, the complainant dies. So that was also issue, whether in the wake of the death of the complainant, that on that score your lordship was kind enough.
Then whom do you can't now implement also. His notice was issued, what do you say?
Oh. The complaint petition is explicitly clear. That is a civil nature.
Yes.
Civil nature. The opposite party should be a party. So I'll do.
The complainant, the opposite party has died.
Yes.
That's the problem. I issued notice only for that. The council for the state is not in such a matter, and seeks the government is the matter.
Online copy of the from the court.
Why don't you do it? Court, everything court will do. You file any petition, and then I'll keep on collecting annexures for you. What is this going on? Either you file or you don't file. I told you to file the reply. You don't file, and you ask me to collect from the court and decide the matter. And many a time, what happens? I file the petition, says that you ask the court to give the annexures. I'll keep on collecting annexures for you. What is this? You should file reply. Yes.
62. Is there an interim order to continue or the LCR to?
Was there any interim order? I don't think there was.
LCR?
My Lordship, on behalf of Mr. Senior Advocate Gopal Agrawal, I kindly seek for a short adjournment.
You should have told him he's sitting in the morning.
My Lordship,
Tomorrow evening, he would have said, I would not have come.
My Lordship.
But I would have to be come here because I have to be present tomorrow.
But you could have spent better time somewhere else.
Correct. Enjoyable time.
My Lordship, election matter has
Now you
been
pay cost to him
specifically-
because of the difficulty.
It will be very heavy.
I know he can't match it.
No, I don't want him to be my lawyer. Let me,
Yes.
anyway, he wanted.
Why, are you going to file rejoinder to the?
Since they are asking for time, I will file a short affidavit. Because, my lord, today what is happening? They say even if the predicate offense has gone, still PMLA can be made. According to them
Yes,
now.
that's right.
Okay.
No. That they say that predicating offense qua the other co-accused has gone. But insofar as you are concerned.
For my, against me is gone.
Okay.
Against me, even if it is gone, against other accused are pending.
So therefore they continue. That's what.
That is the submission PMLA can continue.
Right.
What is the reason? Reason is section 70 of the PMLA.
Right.
Number 3 judgment of the 2 of the High Court and 1 of the Supreme Court.
Yes.
But while quoting those judgments, they have not filed the judgment. Now they have chosen which paragraph they will put. It's all up to them. I have compiled those judgments. I pulled out those judgments. I have pulled out 3 judgments of the Supreme Court which says if the creditor offense goes against the accused, PMLA is not maintained. It goes. But subject to what? I like to file a short affidavit enclosing.
And file a compilation so that it will be. File a compilation with judgment.
I will file a compilation to your law. First, 3 judgment of the Supreme
And
Court.
give the advance copy
Give
so
an
that
advance copy
it
to
will not be
them so that
urgent.
they should be prepared. Lord, can your lordship, can I request, because Lord, today is it, next is 28 is Tuesday. With 28 I'll be in Patna, so I can come on 29. If your lordship so please, I don't know.
You have
Yes, my Lordship, 29 would be fine.
Okay, much okay.
Yes.
29th interim order.
Much okay.
In the meantime, Mr. P. N. Misal and senior counsel submits that he would be filing a convenience compliance compilation by next date of hearing and advance copy of the same.
With a short affidavit.
Will be said,
I'd like to file
short
a short
affidavit, advance copy of the same be supplied beforehand to the
I'm
constable.
giving advance. They say that there are scheduled offense against the officers. Interesting, no PMLA is filed against them. I put it in the affidavit. But PMLA should, in spite of quest against me, PMLA should continue because of section 7. I'll argue that point.
But in the other accused persons,
No. Officers.
Then you have a difficult task to answer.
Yes, my Lordship.
Okay.
I'm only putting a notice. This is my argument. I'll put it in a short affidavit so that your lordship will.
Yes, you note down, madam. Note down and
Yes, my
just
Lordship,
tell
I've
me
noted it down.
Can
Deal
it
with
fix for 2 of? I don't know.
29?
What is that be? But
See, time fixing a time is neither here nor there.
okay, it's all right. No.
My Lordship, kindly please fix the matter on 3rd of February.
No, 29th he said he's coming for some.
I mean, Patna,
We'll see. We'll see in 29th. Let him come.
Okay. Yes, my Lordship.
It may be important. Yes.
Applies.
Yes, interim order.
Lordship. Lordship, here 2 elephant tusks were recovered from the vehicle of the petitioner.
Then the petitioner was not arraigned as an accused by the wildlife provision. Then petitioner moved a 457 CRPC petition before the learned SDGM, which was rejected because the confiscation proceeding was pending. Then the against that order, petitioner moved to the session court in revision. The session court upheld the decision of the learned SDGM. Then the petitioner is before this court for release of vehicle. Who is this?
Yes, my lordship. My lordship, first of all, my lordship, when the confiscation proceeding was even initiated, the jurisdiction of criminal court get barred because, my lordship, the accused was held by the forest officer, not by the police officer. And section 56 of the Forest Act says that when there is a reason to believe that when there is a reason to believe that a forest offense has been committed in respect of any forest produce, such produce together with all tools, ropes, chains, boats, vehicles, or cattle used in committing any such offense may be seized by any forest officer or police officer. Clause 2, every officer seizing any property under this section shall place on such property a mark indicating that the same has been so seized and shall, as soon as may be, except where the offender agrees in writing to get the offense compounded.
Yes.
Then, my lordship, make a report of such seizures to the magistrate having jurisdiction to try the offense on account of which the seizure has been made. And provided that when the forest produce with respect to which such offense is believed to have been committed in the property of the government and the offender is unknown, it should be sufficient if the officer make, as soon as may be, a report of the circumstances to his official superior and the divisional forest officer. Section 2A says that, my lordship, when an authorized officer seizes any forest produce under subsection 1 or where any such forest produce produced before him under subsection 2 and he is satisfied that a forest offense has been committed in respect thereof, he shall order confiscation of the forest produce so seized or produced together with all tools, ropes, chains, boats, vehicles, or cattle used in committing such offense. And accordingly, my lordship, when the confiscation proceeding has already been initiated, so the vehicle cannot be released. And that is the order that for that my
He is seeking interim jima.
No, my lordship, his prayer is to release the vehicle, my lordship.
Section 58 of the Odisha Forest Act mechanism.
Are you seeking interim jima or
interim?
Where is that? Your application, show me up.
No.
It's mentioned in the
yes, ma'am.
Show me your
annexure 1.
Yes.
Let's say it's mentioned in the judgment.
Where is your application? Show me the
application. So, page 13, lordship. Last paragraph. It has found it's on confiscation.
Yes. What is the stage of the confiscation proceeding?
My lordship, as per the order of my lordship, the confiscation proceeding is pending before the ACF.
What is the stage?
Stage, my lordship, we have not taken the instruction.
I have my own judgment. I say that there is no bar. Even confiscation proceeding is there. Interim jima can be granted. He is asking basically interim jima. He is not happily worded. The application is not happily worded, but basically he is asking for interim jima of the vehicle. If confiscation is there, he will give indemnity bond, whatever conditions are there. That's the reason I issue notice.
My lordship, kindly give me some time. I will take the instruction.
Tell me what is the stage of confiscation. Are you participating in the confiscation?
Yes.
Participating. Do you have the details of confiscation proceeding?
No.
Mr. Maharana, the counsel for the state seeks an adjournment to get instruction regarding the stage of confiscation proceeding. Please the matter up to yes.
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 Lordship admits, my lord. 64, my lords, may
as a last chance, my lords, pass over for the day, my lord. The reason being, the another two cases your lordship assigned me, the 65, 66, my lord. My friend appears in both the cases, can be disposed of, both matters can be. That's why when I pray for any other day, my lords. This is my last, I prayed time in that case, my lords.
Who is appearing?
This you should have told me earlier. No?
He's waiting, sir.
No, no, I've been informed to his staff, my lords, but I informed to his staff.
Which staff?
I don't know.
My juniors are here. Everybody is here. Nobody knows. Huh?
Now it is between you.
All right.
I've been informed.
He has come against discharge. Long 17 years back.
Accused has been discharged.
Person
Already discharged.
Yeah, discharged. State has come up.
Yeah.
No,
What will you do? Discharge 17 years. Even if he's put to trial, no witness will turn up. And it will end up in acquittal. This is a wastage of time and burden on the court.
Demonstrated that there is no monetary loss. And in turn, there is a monetary gain, not 5 times.
So let it die at his own death, because there can't be a stay. He's discharged. The only thing is, there is no stigma also attached to you because you are discharged.
Yes.
Discharged. Oh, I'll hear it. Then after 2 weeks, then. Huh? 2 weeks. On the request of Mr. Das. Mr. Krishna. Yes.
Lord, here is the case, my lords. Lordship, to refresh your lordship memory, I learned Fred on the press court case upon
60?
65 and 60. Here is the misappropriation of GPF amount in one case, another case, the same petitioner in both the cases, 65 misappropriation of GPF amounts, another case misappropriation of house building advance by purging the signatures of another teachers.
Yes.
And my ground for discharge is the complainant is dead, whose signature I have allegedly forged. And the handwriting expert's report is that no definite opinion can be given on the basis of the materials available that signature has been forged.
Yes.
You last
And that
occasion,
is-
lordship.
And your lordship, in order dated 2/8/24, your lordship asked my senior to address on that.
Furnish the charge sheet and all this. I'm placing the small matters. If lordship permits, my lord, I'm placing for the charge sheet, my lords. During the course of investigation, it is transferred that note sheet, page 6 of the relevant GPF sanction file of Office of DIF School Kendrapada, Sri Navkishore Das, Junior Clerk, submitted proposal to may I pass on this?
No,
The one part.
because there is nothing in the record.
Correct. my lords.
How will I decide?
In fact,
Yeah,
that,
it's only one page. my lords.
handwriting expert's opinion.
Where is that?
Well, I have got it through PP, but no signature, nothing.
See, in the paperless thing, what happens is,
Yeah,
I hear it,
it has to be filed.
and judgment is reserved.
My
Thereafter, I will keep on searching paper, there is nothing,
Yes.
and dictating
relevant matters are not
completely blank.
Your lordship may kindly see this.
No,
Because
file
it is
that,
not-
it
because
has
it
to
is-
come on record after.
Because it is not sealed from the court or the public prosecutor, I couldn't file it. My learned senior can get it from the
No,
CD.
I have to file it. No, if
This
filing
is
the
the-
should be there.
The difficulty is not with you people,
I can
difficulty is
file
with the
it.
court.
I
You
can
file it, how does it make difference?
But
How
let
you
I-
file it?
What they
file
going to say copy that.
Unless it is filed, it
Annex
will
of
be difficult.
मैं annex और करनी revision टा बोले खाली impugned order टा दीजिए and he finds.
अच्छा मत दे दिए कॉपी तो move file करो.
Mr. Mishra, let me-
E-filing.
petitioner, seeks to place on record additional document to substantiate the case. Let him do so within a week. Please sit in first week or second week. Interim arrangement made on 21/10/2024 shall continue to list it up. Yes,
Next item similar.
similar.
Same
Both
order.
matters continue. Okay.
67 is that case. Your lordship wanted me, my learned senior, Mr. Mishra has submitted certain document, bunch of documents. Say I procured all this by resorting to RTA Act, my lords. All those documents I referred to the department, my lords. They said it's not part, subject to correction. So they are not, these are not part of the charge sheet, my lords. But they are procured. We find out the source because all the documents are government records. So they need some more than they have to go to other departments where these copies have been supplied to the petitioner's counsel. I'll just take only last chance, because the entire case hinges on their particular documents. They
Let
realize.
interim order continue and list it for hearing.
It's not that maybe given up.
Well, last time interim order was not extended.
I've seen it. Immediately I saw that only. Because the previous date there was an interim order.
No.
Very
He is a fair counsel, Lords.
No.
He's a fair counsel.
So therefore I just see the interim order.
No, may I submit one thing? Here, so many last chances have gone here. So
yes,
and after last chance, there is last and final chance.
It's just Mishra is correct, my lord. But this is one case, my lord. I was crossing shoulder, not to him. So other series of lawyers.
After last chance, last and final chance is also there. This is last chance. There are last and final chance. Don't take further time because he is.
I agree. I assure this. I assure to him also because in fact I asked them. Because this is not the part of the charge sheet. So how can I give all this answer and all this thing? Let me find out from which department they procured document. They have to go to other departments.
Last time.
And if we don't get instruction next time also, I will conclude my submission. I understand the predicament of other persons, my lord. Here the interim is there, lords.
May I just
last time who also critical. Interim order is there, you have not taken interim order. Wherever there is interim order, unless I say otherwise, interim order to continue. Right on, interim order to continue. Yes.
Here, your lordship had directed me to prepare a convenience compilation and just.
I think give advance copy.
While I am giving that may be recorded because this.
Mr. Mishra and senior counsel has handed over.
Same
Court put a convenience compilation
to Mr. Das, to Mr. Das in advance.
Index
copy already served today.
That's for
in court, lords.
This is the matter for final hearing. Entry order to continue.
I got a good term also. Convenience complaint.
This is always there.
Good.
This is the practice there in Delhi High Court also. We generally, because it's a voluminous record, referring to different pages is very difficult. So whatever you are referring, the relevant part, take it out.
Convenience complaint.
Convenience complaint.
Good.
And it makes it easier for all.
Mr. Mishra, when he was appearing there also, I gave the same direction.
Yeah.
Convenience complaint. Compilation has to be there with judgment and all. So then what happens is it is easier for the
all concerned
court to give dictation.
For all concerned.
You leave it every paper besides and refer to that and finish it up. Yes.
We are grateful to you.
Thank you.
May I please? Appeal against conviction.
It would have.
Several times they have taken adjournment.
No, but Mr. Rizvi is not.
I can. In fact, before I making that kind of mention, a series of adjournments.
Series of adjournment they have taken.
I understand his difficulties, but
it can hardly be taken up half an hour. In an identical case, my lord, your lordship set aside the judgment, my lord.
That is the reason you are pressing. Otherwise,
yes, matter. Similar matter.
If in the identical matter I would have convicted, you would not come.
Certainly not.
He in fact came as a last item.
Let it be in the weekly then.
Can it be taken up tomorrow, my lord? Yes, but my senior also can it be taken?
Weekly asla hai jibo.
Weekly asla ho podu ni paas it. Now he is in deathbed. Now the appellate is in deathbed, my lord.
In fact, when my learned friend came as the last item, always last item is a sweet item. With a flash of smile on his face.
By the time we reach the last item on the board, everybody is exhausted.
And the appellant is also in the deathbed, madam.
And your day is over today. My day starts.
No, I told that you are at a belated stage.
Can it be taken up tomorrow?
Yeah, we'll see.